Just a moment, please.
They're just connecting the audio. I can advise, Madam Chair.
Thank you. They're not ready yet, I think. They're connecting the audio.
Hello.
Mr. Wedke?
Can you hear me, panel?
Yes, we can. Thank
Right,
you.
thank
Good
you.
to have you. Good morning. The tribunal is proceeding in the matter of the First Nations Child and Family Caring Society of Canada and all versus the Attorney General of Canada. And more specifically, to hear a motion jointly brought by the AFN and Canada for a confirmation that a $20 billion compensation settlement satisfies the compensation orders made by this tribunal. The panel acknowledges that this virtual hearing originates from the tribunal location in Ottawa on the traditional and unceded territory of the Algonquin peoples. Before we call for appearances, I would like to address and acknowledge the victims, survivors, in this case, for your courage and your determination. You are overcomers. Each First Nations child is a hero and precious beyond measure. You will change history. This request arises in a context of a complaint brought by the First Nations Child and Family Caring Society of Canada and the Assembly of First Nations against Canada on behalf of First Nations children and families. In 2016, the tribunal found that a complaint was substantiated and that Canada engaged in racial and systemic discriminatory practices in its provision of services to First Nations children and families. The tribunal panel has issued extensive orders to eliminate systemic discrimination, prevent it from recurring, and to reform the First Nations Child and Family Services Program and services, including remediating the discriminatory funding framework for First Nations Child and Family Services, and shifting towards a prevention and First Nations communities-led approach to services in order to seize the mass removal of children from their homes, families, communities, and nations. The tribunal has retained jurisdiction to address the remaining remedial matters pertaining to reform, implementation, and long-term remedies. These reforms are First Nations-led and will be sustainable for generations to come. They aim to eliminate discrimination and prevent it from reoccurring. In 2019, this tribunal panel ordered compensation to be paid to victim survivors for the harms they have suffered and said as follows. It's an opportunity for us, the panel, to express what we've written in our decision in 2019 that specifically address victims and survivors. This ruling is dedicated to all the First Nations children, their families and communities who were harmed by the unnecessary removal of children from your homes and your communities. The panel desires to acknowledge the great suffering that you have endured as victim survivors of Canada's discriminatory practices. The panel highlights that our legislation places a cap on the remedies under Section 53.2E and 53.3 of the CHRA for victims, the maximum being $40,000, and that this amount is reserved for the worst cases. The panel believes that the unnecessary removal of children from your homes, families, and communities qualifies as a worst-case scenario, which will be discussed further below, and a breach of your fundamental human rights. The panel stresses the fact that this amount can never be considered as proportional to the pain suffered, and accepting the amount for remedies is not an acknowledgement on your part that this is its value. No amount of compensation can ever recover what you have lost, the scars that are left on your souls, or the suffering that you have gone through as a result of racism, colonial practices, and discrimination. This is the truth. In awarding the maximum amount allowed under our statute, the panel recognizes to the best of its ability and with the tools that it currently has under the CHRA that this case of racial discrimination is one of the worst possible cases, warranting the maximum awards. The proposition that a systemic case can only warrant systemic remedies is not supported by the law and jurisprudence. The CHRA regime allows for both individual and systemic remedies if supported by the evidence. In this case, the evidence supports both individual and systemic remedies. The tribunal was clear from the beginning of its decision that the federal First Nations Child Welfare Program is negatively impacting First Nations children and families it undertook to serve and protect. The gaps and adverse effects are a result of a colonial system that elected to base its model on a financial funding model and authorities dividing services into separate programs without proper coordination or funding, and was not based on First Nations children and families' real needs and substantive equality. Systemic orders such as reform and a broad definition of Jordan's principle are means to address those flaws. Individual remedies are meant to deter the reoccurrence of the discriminatory practice of similar ones, and more importantly, to validate the victim survivor's hurtful experience resulted from the discrimination. So we, the panel, are here to listen to all the parties with an open mind and heart. However, we may jump in and ask questions. We will hear and consider carefully every party's important views. For the task at hand, I just want to speak peace. Peace so that we can all proceed in a good and respectful way. I understand that the issues to be discussed can be triggering for survivors. If this happens, please reach out to someone you trust. And there's also a helpline. It's called the Hope for Wellness Hotline. And the number is 1-855-242-3310. 1-855-242-3310. The tribunal now calls for appearances in the same order that each party will present their submissions. Thank you. That would be Mr. Watkey for the AFN, and then so on.
Good morning. Good morning. Yes, Stuart Watkey for the Assembly First Nations. I'm joined here with my colleagues Diane Corbier, Jeff Calper, Adam Williamson, and Lacey Cassis.
Thank you.
Yes, good morning, Member Marshallton, Member Lustig. I'm Paul Vickery, appearing for the Attorney General of Canada. With me are Sarah Dawn Norris and Christopher Rupert, who are with the Department of Justice.
Thank you.
Good morning, Member Marshallton and Member Lustig. My name is Darian Bascatawang, and I'm here on behalf of the Chiefs of Ontario. Thank you.
Thank you.
Good morning, Madam Chair and Member Lustig. My name is Christopher Rapson. I'm appearing on behalf of Anishinaabe Nation. And with me is Mr. Brett Robbins, also appearing on behalf of NAN.
Thank you.
Good morning, members. My name is Sarah Clark, and I'm here today with David Taylor on behalf of the First Nations Child and Family Caring Society. Thank you.
Thank you.
Good morning, members. My name is Anshu Juyal, and I am representing the Commission along with my colleagues Jessica Walsh and Brian Smith.
Thank you. Okay. So thanks to everyone. Mr. Watkey, are you ready to start with your submissions? And I believe you have a housekeeping matter first.
Yes, we are ready to proceed.
Thank you.
Good morning. Any panel member, Marshallton and Lustig, counsel for parties, First Nation citizens who are watching this proceeding today across Canada. It is a pleasure to be here before you today. My name is Stuart Watkey, along with my co-counsel, Diane Corbier, Jeff Calper, Adam Williamson, Lacey Cassis, Nathan Surkan. We are representing the Assembly of First Nations at this proceeding. We are also joined by class counsel, Robert Kugler, David Stearns, Jolie Walker, and Mohsin Sadiq, who are observing this proceeding. And we are all in this room today. Before I begin my submissions, I have a couple of housekeeping matters. There is one error in our reply, paragraph 85B. There's a note where it says that as outlined in Appendix A, there is no Appendix A to our reply, and we ask that you disregard the words as outlined in Appendix A.
Yes,
throughout our submissions, the AFN will be referring to our written submissions, the affidavit of Janice Valia, the reply submissions, the Caring Society submissions, the Commission submissions, the affidavit of Janine Courar, the compensation framework, and of course the final settlement agreement. The AFN relies on its written submissions and reply in relation to this motion. I would like to start off by noting that the AFN is one of the complainants to this proceeding and is the requester of this motion. We are seeking this tribunal's endorsement of the compensation final settlement agreement as fully satisfying this tribunal's orders related to the compensation. In the alternative, and if required, we are seeking an order from this tribunal to vary the orders and bring them in line with the final settlement agreement. In December of 2021, the Assembly of First Nations secured a commitment from Canada for a $40 billion settlement. $20 billion was earmarked for compensation under this commitment, as well as $19.807 billion for long-term reforms. The AFN would like to acknowledge that this settlement of this size would not have been possible if it were not for the forward-thinking and innovative orders pronounced by this tribunal. The AFN recognizes that we were able to reach this settlement because of the panel issued an authoritative and decisive decision whereby Canada was ordered to pay compensation in the amount of $40,000 to victims of Canada's discrimination. The AFN and Mission Council were able to leverage your ruling and work with Canada to include additional enhancements to the existing orders. While the Tribunal's compensation orders were profound, the statutory limitations of the CHRA, Canadian Human Rights Act, imposed the ceiling on the level of compensation victims of Canada's discrimination were entitled to receive. We note that the panel was mindful of this statutory limitation in awarding the maximum compensation amount allowable under the Act and the inherent unfairness it creates. The compensation decision, 2019 CHR 239, this panel stated at paragraph 85, some children and parents or grandparents may have suffered more than others. However, the compensation remedies are capped under the CHRA, and the panel cannot award more than the maximum amount, even if it is a small amount in comparison to the degree of harm and racial discrimination experienced by nation's children and families. The final settlement agreement is a product of sound direction from this panel and your orders on compensation, while allowing AFN, Mission in Canada to explore options that are not constrained by the Canadian Human Rights Act with respect to compensation. The AFN, Mission in Canada have produced a compensation package that, while based on this panel's orders, goes above and beyond your orders. We were able to take a good decision and broaden it to include more individuals into the compensation scheme and substantially increase the time period for eligibility by an additional 15 years. We were also able to include those children who were removed from their homes but continue to live in the communities into our compensation scheme. Otherwise, they would be excluded under the CHRT process. We recognize that we could not have accomplished this without this panel's orders. No other settlement in Canada has come close to the level of compensation being made under the final settlement agreement. The AFN submits that the final settlement agreement is different from other settlement agreements in the following respect. No other settlement agreement was developed from the perspectives of First Nation class members. Our final settlement agreement was developed on the views and contributions of our representative plaintiffs. The claims and application process were developed based on how claimants would like the process to function. Removed child applications will be pre-filled by the administrator based on records, which will remove a heavy burden on claimants to reflect their experience and record of their journey of life on a piece of paper. The parties themselves will take on that burden. We've learned from past mistakes and from other class actions and have taken steps not to repeat those mistakes. In past class actions, claimants were subject to the burdensome claims process. They had to prove their levels of harm. Claimants were not provided with clear information on what documents they needed to support their application, which in some cases, unfortunately, led to them not receiving the full benefits they were entitled to. Claimants were subject to interrogatories. Some claimants were not believed. The parties to the final settlement agreement agreed it was important not to make children and young adults testify to the levels of harms that they have endured. So we created a process that provides compensation on objective criteria that will negate the requirement of children having to fill out forms and recount the harms they endured throughout their lives. Under our process, Canada has no right or ability to contest the payment of compensation or the amount of the award. Canada cannot require claimants to testify or justify their applications. The final settlement agreement is First Nations led. For the first time, First Nations oversight will lead the compensation process and will be able to determine and provide ongoing direction on any evolving issues, gap, or novel problems that may arise over the next 21 years. It is important to note that securing First Nations oversight and control over the compensation process was a product of give and take. We simply did not want Canada to be involved in the ongoing distribution of compensation or the compensation scheme. We sought to run the process ourselves, but in return, Canada wanted finality. In exchange for Canada bowing out of the administration of the compensation process, the parties to the final settlement agreement accepted the limitation of $20 billion on compensation. Now, the Caring Society seeks not to disturb this panel's compensation order and set compensation at $40,000 per claimant. This would result in an open-ended process, as Canada would be liable for all claims. Canada would have a role in the ongoing administration of the claim process and the verification and processing of applications. In short, what the Caring Society and the Commission are proposing is not a First Nations-led process. The AFN is of the view that First Nations-controlled processes is a preferable and more culturally relevant process for First Nation claimants. And the $20 billion limit on compensation is a solid figure we can live with, for a number of reasons. First of all, the classes of claimants are budgeted and staggered. The estimated budgets are reasonable. The parties are able to make adjustments to the budgets over time. A good portion of the $20 billion will be invested, allowing the fund to grow over time. This will assist in ensuring that just compensation will be payable over the term of the settlement agreement. We would submit that the Tribunal should take comfort in knowing that the AFN, Sioux and Man support and endorse this agreement. These are the three parties to this proceeding that directly represent First Nations and their citizens, which this panel has noted in the context of compensation. And here at the compensation decision in paragraph 201, this panel stated that we should be able to speak on behalf of children and voice their needs and seek redress for compensation. We are the organizations that do represent those children. The AFN encourages this panel to take a human rights and justice-based mindset in considering the many benefits the final settlement agreement will have on First Nations victims of Canada discrimination. We ask that the panel reject the Commission's and Caring Society's request that this panel take a technical view of this matter, which exalts legal precedents and principles over the rights of First Nations children and families. As has been previously noted by the Commission itself, the Tribunal's decision-making has been bold, breaking new ground, and have few, if any, analogous precedents. Its efforts and processes are not unreasonable, but reflects the magnitude of Canada's discrimination practices. This is found in the Commission's factum on the judicial review at paragraph 73. This remains the case in the context of this final settlement agreement. There are no analogous precedents for this tribunal to consider in a settlement of this size and scope, and the infringement on the human rights it seeks to redress. The tribunal must recognize that its broad and ongoing jurisdiction continues to inform this process, and the bold strokes continue to be called for. The AFN is cognizant that there will be ramifications should this panel not grant AFN's request and endorse the final settlement agreement, and we will speak a bit about that later. We note that the final settlement agreement is accumulation of 2 years of negotiations that provides more benefits than the current compensation orders. We ask that this panel finds that the final settlement agreement satisfies its compensation order. Before going much further, I wanted to provide you with a roadmap of what we'll be saying in our submissions. We'll start out with a brief description of the facts of this matter. Next, we'll discuss the recommendations for class counsel to support the approval of this final settlement agreement. Thirdly, we'll provide the court with some focus submissions on the panel's jurisdiction to enforce the final settlement agreement, or I should say, to endorse the final settlement agreement. We will then discuss this panel's discretion to declare that the final settlement agreement satisfies compensation orders. My colleague, Ms. Corbier, will then provide an overview of the final settlement agreement and demonstrate how the agreement aligns and complements this panel's compensation orders. From there, my colleague, Jeff Cowper, will address the few instances where the final settlement agreement necessarily deviates from the compensation orders solely to provide clarity and certainty. Finally, I will provide submissions on additional factors the panel should take into account and under consideration in its endorsement of the final settlement agreement. Before I get into my submissions, the AFN would like to acknowledge the resilience, strength, and perseverance of those that went through the child welfare system or faced children principles, delays, and denials. The AFN also acknowledges the bravery, resilience, and compassion of our representative plaintiffs who've agreed to take on a heavy burden for the benefit of other First Nations children and young adults across Canada. They have added a very human element to our work and given the AFN and the motion team momentum to complete the final settlement agreement. The AFN has traveled across Canada to discuss the final settlement agreement. We have heard the voices of our citizens who want us to finish the work and get compensation into the hands of those that are entitled to it. We have heard very loud and clear, let's get the compensation out the door so that individuals can move on with their lives and continue their healing journey. I'll now go into the facts of the case, and many of the facts are outlined in our written submissions. Well, we would note that since 1998, the AFN has been engaged with Canada to address the significant inequities in the funding from the Department of Indian Affairs at that time, now ISC Canada, Indigenous Services Canada, for the First Nation Child and Family Services Program. These deficiencies and inequity were revealed in various reports and reviews, such as the National Policy Review and the one-day reports. Following these, I should say, Canada's inaction following these joint studies resulted in both the Assembly First Nations and the First Nation Child and Family Caring Society filing a human rights complaint in 2007. On January 6, 2016, this panel substantiated the complaint in its seminal merits decision. The tribunal held that Canada was discriminating against First Nation children and families living on reserve and in the Yukon through its First Nation Child and Family Services Program and related provincial territorial agreements, and by denying and are differentiating adversely in the provision of child and family services in violation of sections 5A and 5B of the Canadian Human Rights Act. Similar findings were found with respect to Jordan's principle. In substantiating the complaint, the tribunal ordered Canada to cease its discriminatory practices and reform the First Nation Child and Family Services Program and the Canada-Ontario 1965 Indian Welfare Agreement to address the findings of the tribunal. Canada was also ordered to cease applying its narrow definition of Jordan's principle and to fully implement the full meaning and scope of Jordan's principle. The AFN in Canada sought an order of compensation. However, we had diverging views on the issue of indigenous compensation versus the establishment of a trust. The Caring Society's position back in 2019 was that they favored compensation and that the payment of all compensation for the victims of Canada's discrimination to be paid into the Spirit Bear Trust Fund. Their position is reflected in the written submissions dated April 3rd, 2019, which provides at paragraph 38. The Caring Society is of the view that special compensation, $20,000 under the Act, ordered for each First Nation child, individual affected by Canada's FNCFS program, who is a child who has been taken into out-of-care home since 2006. And for every First Nations individual who has, as a child, now received eligible services or a product pursuant to Canada's willful and reckless discriminatory approach to Jordan's principle from 2007 to November 2017, should be paid into a trust for the benefit of those children. The Caring Society proposes that that the trust be called the Spirit Bearer Trust. The purpose of paragraph 39, the purpose of the Spirit Bearer Trust will be able to provide access to services through these funds placed in trust for services such as culture, language programs, family reunification programs, counseling, health and wellness programs, and education programs. The AFN took a different view and approach to compensation. The AFN was the only party to advocate that compensation be paid directly to victims of Canada's discrimination. The AFN's position is reflected in the compensation decision at paragraphs 34 and 35. At paragraph 34, the AFN has been mandated by resolution following a vote of the Chiefs and Assembly to pursue compensation for First Nations children and youth in care and other victims of discrimination, and to request the maximum compensation allowable under the Act based on the fact that discrimination is willful and reckless, causing ongoing trauma and harm to First Nation children and youth, resulting in a humanitarian crisis. Paragraph 35. The AFN submits that compensation be awarded to each sibling, parent, or grandparent of a child or youth brought into care as a result of neglect or medical placements resulting from the response to discriminatory practice, and that such compensation be the maximum allowable under the Act. Two very different approaches to compensation at the time. Had the Caring Society submissions prevailed at that time, we note that not 1 cent, not 1 penny would be paid to victims of Canada's discrimination. It would have gone into a trust fund. The AFN's approach was that children themselves went through the child welfare system. Parents or the caregiving grandparents had their children removed from them. Very tragic moments in one life. And that they should be paid compensation directly because they suffered the harm. We note that the Caring Society's desire to have all compensation be paid into a trust fund was resoundingly rejected by the Canadian Human Rights Tribunal, this panel. In its compensation ruling, the CHRT accepted AFN's position on compensation and held at paragraph 260. The panel prefers AFN's request that compensation be paid to victims directly following an appropriate process instead of being paid into a fund where First Nation children and families could access services and healing activities to alleviate some of the effects of the discrimination they experienced. The panel is not objecting to a trust fund per se, rather it objects to the compensation to be paid into a trust fund to finance services and healing activities in lieu of financial compensation as suggested by the Caring Society. The AFN notes that the tribunal was satisfied on the evidence that the removal of children from the communities and families was traumatic and caused great pain and suffering to both children and their families occurred. The panel accepted that some children and the families also experienced serious mental and physical pain resulting from delays and denial of health-related services. In its compensation decision, this panel awarded $20,000, the maximum amount of pain and suffering for each First Nation child who was removed from their home since 2006, and each of their parents or grandparents where the removal was necessary. The tribunal determined that Canada knew its policies were harming children. However, the government chose to put their financial interests above the interests of First Nation children. As a result, of this willful, reckless behavior. This tribunal awarded each First Nation child that was removed from their home since 2006 and where the removal was unnecessary, each of their parents and grandparents an additional $20,000. In short, the panel accepted AFN's position that the maximum amount under the CHR Act, $40,000, would be payable. At that time, the tribunal ordered Canada, the AFN, and the Caring Society to develop a compensation plan and return to the tribunal with propositions by December 2019. On February 21st, 2020, Canada, the Caring Society, and Canada submitted a draft compensation framework to the tribunal. The jointly developed compensation framework establishes a distribution mechanism in compliance with the tribunal's directions and facilitated a culturally safe and expeditious distribution of compensation. We note, however, that the work in the compensation framework remains uncompleted at this time. In two rulings subsequent to the compensation order and the approval of the compensation framework, this panel considered the issue of eligibility of children who should be covered under Jordan's principle. The first decision, dated July 17, 2020, cited as 2020 CHR 220, concerns the criteria for determining individuals who are eligible for consideration under Jordan's principle. The order was partially modified in the tribunal's subsequent decision, dated November 25, 2020, cited as 2020 CHR 236. In November of 2020, the tribunal made its final ruling on eligibility for Jordan's principle. Jordan's principle would apply where a child is registered or eligible to be registered under First Nation, under the Indian Act, as amended from time to time. A child has one parent or guardian who is registered to be eligible to be registered under the Indian Act. The child is recognized by their nation for the purpose of Jordan's principle, or the child is ordinarily resident on reserve. These two additional rulings had the effect of modifying and impacting the compensation order. In October 2019, following the release of the compensation decision, Canada filed an application for judicial review of both those decisions, as well as the compensation and Jordan's principle. Canada argued that the clarified eligibility for Jordan's principle had the effect of expanding entitlement to compensation further through the compensation decision. Specifically, Canada sought to dismiss the tribunal's decision and dismiss the claim for monetary compensation under its judicial review. On October 29, 2021, the Federal Court of Canada upheld Canada's the compensation decision, which upheld the tribunal's compensation decision, finding that it was reasonably given and the broad discretion provided under the CHRA to fashion appropriate remedies and to that fit the circumstances was within the panel's jurisdiction. We note that Justice Favel ended his reasons dismissing Canada's judicial review with the following powerful and poignant reminders. It's found at paragraph 300 of the Federal Court's judicial review decision. Paragraph 300 states, negotiations are seen as a way to realize a goal of reconciliation. It is, in my view, the preferred outcome for both Indigenous people and Canada. Negotiations as part of the reconciliation process should be encouraged, whether or not the case involves constitutional issues or Aboriginal rights. When there is goodwill in the negotiating process, that goodwill must be encouraged and fostered before the passage of time makes the impact of those negotiations. As Chief Poundmaker, a nation builder in his own rights, aptly said, and he's quoting Chief Poundmaker, we all know the story about the man who sat by the trail too long, and then it grew over, then he could never find his way again. We can never forget what happened, but we cannot go back, nor can we just sit beside the trail. At paragraph 300, Justice Favel says, continues, in my view, the procedural history of this case has demonstrated that there has been goodwill resulting in significant movements towards remedying this unprecedented discrimination. However, the good work of the parties is unfinished. The parties must decide whether they'll continue to sit beside the trail or move forward in the spirit of reconciliation. The final settlement agreement is a product of both the foresight of this panel and the federal court to encourage negotiations and a negotiated settlement. The AFN in Canada took upon that those recommendations and those instructions and negotiated a final settlement agreement with our friends, Mission Class Council. We feel that we have implemented those directions brought by this panel and the federal court to look at creative means in which to address some of these issues. Now, with respect to the class actions, on March 4th, 2019, the representative plaintiff, Xavier Mushin, Jeremy Masage, and his litigation guardian, Jonathan Joseph Masage, and Joseph, basically collectively the Mushin plaintiffs, commenced a proposed class action in the federal court under court file number T-402-19, seeking compensation from Canada for its discrimination dating back to 1991. On January 28, 2020, the Assembly of First Nations and the representative plaintiffs, Ashley Dawn Louise Bach, Karen Osachoff, Melissa Walterson, Noah Buffalo Jackson, and by his litigation guardian, Carolyn Buffalo, and Dick Eugene Jackson, filed a class action themselves with the federal court under the federal court number T-141-20, dating back to 1991. Mr. Trout and the AFN also commenced another class action, the Trout class action, bearing federal court number T-1120-21 on July 16, 2021. Mr. Trout sought to represent the class members who had faced a delay, denial, and gap in the receipt of essential services to which the class members had a confirmed need between April 1st, 1991 and December 11th, 2007. What is important about these three class actions? They were consolidated by Madam Justice All-Elaine in February 11th, 2020. But an important aspect of this, it broadens compensation to a large number of individuals. This panel's compensation orders, as we know, goes back from 2006 to 2022, whereas the class action brings in all those individuals back to 1991 to 2022. Under the class actions that were merged, consolidated, there are essentially 6 classes of individuals where compensation is being sought. The removed class, these are First Nation individuals who were removed from their homes between 1991 and 2022. The removed child family class, these are the parents or grandparents or siblings of the members of the removed class. The Jordan's principal class, basically First Nation minors living anywhere in Canada who between 2007 and 2017 had a confirmed need for essential services, faced a denial, delay, or service gap. With respect to that need of essential services. The Trout class, First Nation minors living anywhere in Canada between 1991 and 2007, having a confirmed need for an essential service and faced a denial, delay, or service gap with respect to the needed essential service. And lastly, the Jordan's principal and Trout family class, those parents of both the Jordan's principal class and the Trout class. So once the class actions were certified by the federal court, parties, AFN, Canada, and Mission began looking at implementing the much needed work to deal with all these class actions. One of the first things, of course, we had to do once a consolidated class action was certified was to develop estimates of the class size. And we have a description of that in our factum, beginning at page 10. And essentially, we would note that in some instances, the class sizes estimates were difficult to produce given the lack of direct data available in certain circumstances. To assist class counsel in the negotiations process, Wisdom Class Counsel commissioned an independent report and expert opinion on the size of the removed class by Professor Nico Trocme in collaboration with actuary Peter Gorman. We call this a Trocme-Gorman report. You may recall Professor Trocme's name as he is one of the helpful researchers and contributors to the one-day reports that this panel relied on in the merits decision. A very well-respected individual who has assisted this panel in the past in providing useful information that was instrumental in reaching decisions. Mr. Trocme did assist us with respect to the estimation of the class size. In the Trocme-Gorman report, estimate that there were roughly 106,200 removed children from 1991 to March 2019. Dr. Trocme and Mr. Gordon subsequently advised his class size must be adjusted approximately by another 115,000 people to cover the period from March 2019 to March 2022. The estimated removed child class size was determined based on data we received from Indigenous Services Canada and modeling which took into account gaps in the data. The estimates for the Jordan's Principal class and the Trout class proved to be a little more difficult because the scope of Canada's Jordan's Principal services has evolved since its inception. Also, the Tribunal compelled Canada to cease applying a narrow definition of Jordan's Principal, which created more evolution from just jurisdictional disputes between levels of government to a more holistic child first process. And thirdly, there is little or no data with respect to Jordan's principles for the vast majority of the class period, as the concept of Jordan's principle did not exist until 2005 and was not tracked until 2017. As no direct information was available on the number of individuals who met the definition of Jordan's principle class or the Trout class, we undertook an analysis which was based on recent IFS data, Indigenous Services data, in relation to the number of Jordan's Principal services accessed. The Jordan's Principal class size estimate is derived from data that Canada shared with the APTN National Class Council on the number of approved Jordan's Principal claims for the quarter of 2019 to 2020 fiscal year. This quarter was highlighted by Canada as providing the highest quality of represented data in relation to the full implementation of Jordan's Principle. We note that the data is reflective of the full implementation of Jordan's Principle services. This is where Canada started complying with this panel's orders and started providing services. We note that at the beginning of Jordan's Principle, the evidence pursued in this case demonstrated that at first there were no Jordan's Principle cases that were being approved. We also noted at that time, even if Jordan River Anderson were to file the Jordan's Principle application, it would have likely been denied. That evolution has taken place. Canada was full compliance during this period, and a number of services, not only related to health-related services, but also mental health, education supports, and a whole host of other services were provided to First Nations people. And all of that is captured in this one quarter. And it also thirdly reflects the pre-pandemic numbers. Extrapolating from this very limited data, the Jordan's Principal class estimate is estimated to be between 58,358 people and 69,728 people for the Jordan's Principal class period. We note that there is no precise data available to determine the size of the child class, and as Jordan's principle did not exist during that period. The child class estimate is determined by using Jordan's principal class. Essentially, the parties took a round figure of 65,000, which is slightly higher than the median of the Jordan's principal class size, and we multiplied it by the number of years a child class period is greater than the Jordan's principal class, roughly 1.6. This resulted in an estimate size of 104,000 individuals for the child class. We note that there's no direct data available for the family class. However, the parliamentary report, which was tendered as evidence in this complaint, noted that First Nation children live with an average of 1.5 biological parents or grandparents if the parents are absent. This data was used to estimate the family class size. With respect to the settlement negotiations, the negotiations among the parties were lengthy, extensive, complex, starting in 2019 with the Mission class action and then unfolding as part of the consolidated class action and the child class action. From November 2020 to September 2021, the parties to the consolidated class action, along with the Caring Society, engaged in mediation in accordance with the federal court guidelines for Aboriginal law proceedings with the Honorable Leonard Nadaman as the mediator. The negotiations covered compensation for certain classes in the consolidated class action. Beginning in early November 2021, the parties entered into negotiations outside the federal court mediation process. The parties, by agreement, appointed Honorable Murray Sinclair to act as chair of the negotiations, while compensation discussions were primarily a tripartite negotiation among Canada, AFN, and Mission Class Council. Compensation proposals relating to the various classes of survivors were also presented to the Caring Society and interested parties, Chiefs of Long Territory and Anishinaabe Aski Nation, with opportunity for their feedback. On December 31st, 2021, parties concluded an agreement on principle and compensation, which set out the principal terms for settlement and formed the basis of the final settlement agreement. To inform negotiations on the claims process, Mission Class Council retained an expert to provide an opinion on methodology for objectivity, assessing harm suffered by Jordan's principal and child classes. The proposed assessment framework, which is subject to piloting and testing prior to implementation, seeks to rank the impact of the impunged discrimination on claimants based on objective factors, eliminating the need for in-person interviews or cross-examinations. We will be providing, my friends will be providing a description, so my colleagues will be providing a much broader description with respect to Jordan's principle and how this, all these factors come into play in a few moments. The AFN also recruited a number of experts who have an ongoing, on-the-ground expertise with respect to delivery of services in to First Nation communities as well as in First Nation communities, as well as a measurement of health and wellness from a First Nations perspective. The AFN engaged a circle of experts to ensure that any methodology adopted and tested for the Jordan's principle scheme will be First Nations led. The options expressed by this circle of experts was later informed and informed our approach to the Jordan's principle method that will be piloted. Now, the AFN provided regular dialogue sessions throughout the negotiation process by providing ongoing updates on the status of negotiations and the substance of this settlement across all regions. The AFN and external legal counsel, along with the AFN team members, presented the draft FSA, a final settlement agreement, and received feedback and comments on the compensation amounts and structure. The AFN regions generally expressed support of the final settlement agreement and the importance of distributing compensation to individuals as soon as possible. As a result of this lengthy process, the final settlement agreement eventually received approval by all parties in this in the class actions. Each of the represented plaintiffs fully supports the final settlement agreement, particularly citing the ability for class members to receive payments promptly rather than a lengthy litigation process. B, that it's trauma informed and culturally competent with respect to the claims process. And thirdly, that the principle of proportionality, by which all class members who suffer greater harms will receive higher compensation. And finally, the decision to prioritize child class claimants. On June 30th, 2022, the final settlement agreement was finalized and executed by Canada, the AFN, and Mission Council, and is now subject to the approval of the federal courts. With respect to recommendations of the AFN, it is AFN's position that this settlement satisfies the tribunal's compensation decision and related orders. The AFN views the settlement and the settlement reflected in the final settlement agreement as the best possible resolution to both the complex and lengthy proceedings before the tribunal related to compensation for survivors and the class action. The approval of the final settlement agreement will significantly expand the number of survivors who would otherwise not be entitled to compensation under this tribunal's orders. This includes those children who remained in their communities but were apprehended from their homes, children removed from 1991 to 2006, Jordan's principal children from 1991 to 2006, and a large number of children will get more compensation and be entitled to more compensation than what this tribunal has ordered. The scope and the amount of this settlement agreement cannot be overstated. Compensation will be delivered to hundreds of thousands of survivors of Canada's discrimination. The individual amounts of compensation will have life-changing impacts for many of the most vulnerable and marginalized First Nation members. The AFN views a class action administration with the culturally appropriate protective measures as set out in the final settlement agreement as the most effective and feasible mechanism for delivering compensation to survivors. The AFN has negotiated specific cultural support set out in the final settlement agreement in order to maximize the benefit and minimize the harms associated with the receipt of compensation. The final settlement agreement expedites payments of compensation while honoring substantial and significant work of the tribunal and the parties to the tribunal's proceedings on behalf of survivors. And we would note that Canada will be required to pay the $20 billion in compensation for compensation into a trust fund 30 days upon approval of the settlement agreement by the federal court. The amount of money that will be provided would be almost immediate, and the process would start, which is much different from the current process we have. We note that the tribunal's compensation framework decision requires additional work and negotiation to be done. We also note that Canada has, of course, an outstanding appeal of the judicial review, which is presently in abeyance in the federal courts, in the Federal Court of Appeal. So it is AFN's position that this motion will fully support and implement this tribunal's orders with respect to compensation and the compensation framework. At this time, I was hoping we could take both a break. It's 11:15. Take a break, and I can continue my submissions, and then my colleagues will then continue our submissions. That's okay.
Mr. Watke?
Yes.
Can you hear me?
Yeah.
Okay. There's no issue in taking a break. Would 15 minutes work for you?
Yes.
What I would ask, given the technical difficulties this morning, is that you mute yourself, that everybody, all council mute, but stay on, please, so that we don't have to go through those technical, issues with connection. So, and be back in 15 minutes sharp. Thank you.
Thank you.
Hello, everyone. Can we verify if every council is back, please? Thank you. Before the AFN starts again, am I on mute? No, okay. So before the AFN begins again, I just wanted to repeat that the discussions that we're having during the course of these 2 days may be triggering for survivors. And I would like to repeat that there's a Hope for Wellness hotline, and the number is 1-855-242-3310, 1-855-242-3310. Mr. Wadke?
Yes, thank you. Can you hear me?
Yes.
Thank you. At this point, I will delve into this panel's retained jurisdiction. So we would note that both the Commission and the Caring Society challenged the jurisdiction of this panel to endorse the final settlement agreement and, if necessary, amend its compensation orders. The Assembly First Nation obviously does not share this view. We believe that this tribunal has ongoing jurisdiction, has the required jurisdiction to make the orders and approve or endorse the final settlement agreement. In doing so, we submit that the tribunal has jurisdiction to endorse the final settlement agreement and modify existing orders based on the following principles. Obviously, the Canadian Human Rights Act is a quasi-constitutional document that gives rise to rights of vital importance. These rights must be given full recognition and effect through broad liberal interpretation that will ensure that the objects of the Human Rights Act are achieved. The same is true with respect to the remedial authority of the tribunal, which allows the tribunal to create effective remedies to promote the rights being protected by vindicating the rights and freedoms of victims of discrimination. And thirdly, like many other tribunals, this tribunal has been afforded a very broad discretionary remedial authority. The AFN notes that it appears that the First Nation parties, AFN, KU, and NAM, appear to be the only parties so far that have not challenged this panel's jurisdiction. And we take comfort in that. Now, with respect to this panel's jurisdiction, the tribunal's remedial jurisdiction lies under Section 53.2 of the Act, which establishes that broad remedies are available to the tribunal. This broad and purposive remedial jurisdiction ultimately formed the basis of the tribunal's compensation orders. Even the federal court in judicial review noted that this tribunal is afforded a broad and extensive statutory jurisdiction to fashion appropriate remedies. They note that this is required and it is also supported by Supreme Court of Canada in Zurich Insurance, paragraph 339. We have in our fact note the link. Supreme Court stated that human rights legislation is amongst the most preeminent category of legislation. One of the reasons such legislation has been so described is that it often is the final refuge of the disadvantaged and the disenfranchised. As a last protection of the most vulnerable members in society, exceptions to legislation should be narrowly construed. The AFN notes that this tribunal has crafted remedies using its broad remedial authority, including those to retaining jurisdiction over its subsequent rulings. In the compensation decision itself, this panel noted that the panel retains jurisdiction until the issue of the process for compensation has been resolved by consent order or otherwise, and will then revisit the need for further retention of jurisdiction on the issue of compensation. This does not affect the panel's retention of jurisdiction on other issues in the case. This was further elaborated with respect to the most recent decision on the framework, compensation framework. At paragraph 41 of that decision, this panel noted, the panel retains jurisdiction in all its compensation orders, including an order in its ruling, and will revisit its retention of jurisdiction as the panel sees fit in light of the upcoming evolution of this case, or once individual claims for compensation have been completed. We note that throughout Canada, other tribunals have previously adopted a comparably large and liberal approach when they remain seized of a matter after an award was issued. Examples of these were discussed in the judicial review decision, where the Justice Sable noted that some panels have retained jurisdiction of 10 years to ensure discrimination has ended. The federal court itself upheld this panel's retention of jurisdiction. And it has endorsed the approach that this tribunal has been taking, especially with respect to do we consider and change remedial orders, and has broad discretion to return to a matter. And they cite Canada versus Moore at paragraph 49. So we would submit the tribunal itself has extensively considered the scope of its broad remedial powers. In the past, it has found that its powers and its retained jurisdiction provided it with the ability to endorse payment of compensation. And we would state that that holds true today. As we noted at the outset of our comments, this panel has issued a number of forward-thinking decisions. The merits decision itself was seminal. This panel had changed the law, and with respect to the application of the law across this land, with respect to services being, funding being a service. This whole case itself has been a novel issue after issue after issue, which this panel had the foresight and ability to make binding orders to remedy that discrimination. And we would argue this discrimination continues. The federal court was very clear in the judicial review decision that this panel remains seized of this matter and allows this tribunal to foster dialogue between the parties, effectively promoting a dialogic report, and ultimately contributes to the goal of reconciliation between Indigenous peoples and the Crown. The federal court at paragraph 136 states that the dialogic approach allowed the tribunal to set parameters on its remedial jurisdiction. The panel's facilitation of the dialogic approach itself has emphasized in the compensation decision, where this tribunal has confirmed that the orders would find application once compensation process has been agreed to by the parties or ordered by the tribunal. And that's at paragraph 244. This dialogic report directed Canada to engage in discussions with the APTN and the Caring Society, as well as consult with the interested parties to this proceedings, and including the Commission on the compensation process. This panel clearly stated at that time it was not making a final determination, but was allowing the parties to discuss and return to this panel with proposals. Tribunal also invited the parties to reach out for clarification or any suggestions in relation to the compensation process. This invitation gave the parties flexibility to engage in a dialogic development of the compensation process, which this panel viewed as necessary in the broad exercise of its remedial orders. And we know that paragraph 270, I believe, of the compensation process, the panel said, as part of the compensation, as part of the compensation process consultation, the panel welcomes any comment, suggestion, and request for clarification from any party in regards to moving forward with the compensation process and the wording and/or content of the orders. We would note that the federal court itself took no exception to the tribunal's retention of its jurisdiction and the dialogic approach used within by this panel. The federal court noted that the retention of jurisdiction by the tribunal had a precedent, and ultimately found that the retention of jurisdiction of the dialogical approach were both reasonable within the broad remedial powers of this tribunal. In the JR decision at paragraph 302, the court held that I find that the applicant has not succeeded in establishing that the compensation decision is unreasonable. The tribunal, utilizing the dialogic approach, reasonably exercised its discretion under the CHRA to handle complex cases of discrimination and to ensure that all issues were sufficiently dealt with and that the issue of compensation was addressed in phases. The tribunal ensured that the nexus of the complaint, as discussed in the merits decision, was addressed throughout the remedial phases. Nothing changed. All this was conducted in accordance with the broad authority the tribunal has under the CHRA. The federal court was clear that the approach that this panel has taken throughout this case and its retention of jurisdiction and ability to craft orders and remedies is supported by law. And it is an expression of the fact of the effective remedies in the context of human rights legislation, which are complex. And in this case, many of the issues have come forward without precedent. And this panel was able to look beyond that and create remedies and make new law. It is clear to the AFN that the tribunal's continued dialogic approach is structured in a manner which allows the tribunal to be both innovative and flexible in consideration of human rights cases. Now, with respect to this jurisdiction, the AFN would submit the tribunal has retained jurisdiction over compensation, which is mirrored in each relevant compensation order. The federal court's endorsement of the same dialogical approach stated that the need for flexibility and innovation by the tribunal in exercising jurisdiction ultimately support the tribunal's jurisdiction to, we would argue, consider the FSA as satisfying the compensation decision and the compensation orders. We note that this tribunal or this panel has explicitly reserved jurisdiction to revisit the compensation order and related compensation orders and the compensation framework. And this panel has duly considered the overall evolution of this matter. Further to the federal court's endorsement, the AFN would submit this panel's own analysis with respect to the scope of the broad and remedial powers and the ability to return to evaluate the compensation framework are relevant and are equally applicable in the context of the tribunal's consideration of the final settlement agreement. We note that the AFN submits the tribunal's ongoing retention of jurisdiction over the issue of compensation and the evolution of this matter still provides the tribunal with broad remedial powers in this context, and its provision under its proceedings make suggestions and seek clarity as needed, and provide sufficient authority for AFN Canada to present the final settlement agreement to this tribunal for consideration and endorsement. The final settlement agreement represents a clear evolution in this case before the tribunal and is a product of the dialogic process that is so heavily informed and influenced by the representatives of the First Nations parties. The final settlement agreement is a product of extensive negotiations between the AFN and Canada, who are both parties to this tribunal proceeding. We would note that the parties to the class action had negotiated over 18 months to reach an appropriate settlement for the class and the development of an effective implementation scheme. Our friends from the Caring Society were involved in part of this process before Justice Madaman and were consulted in the course of the negotiations. AFN and its class counsel, along with Mushin class counsel, provided multiple opportunities for comments and feedback. Responses were given to the parties when necessary. The AFN submits that the Tribunal's consideration of the final settlement agreement is grounded in the fact that effective remedies in the context of human rights legislation requires innovation and flexibility on part of the Tribunal, which is facilitated by the nature of the Canadian Human Rights Act. As consistently noted and relied upon by the Tribunal during its proceedings in relation to the broad remedial powers, this is, I believe, at paragraph 75 of the framework decision. This panel stated, in short, I have no doubt that if the Act is to achieve its purpose, the Commission must be empowered to strike at the heart of the problem and prevent recurrence, to require steps be taken to enhance the work environment. That was this panel referencing the Rubichard decision, the Rubichard paragraph 15. It is the AFN's position, and we submit that the Tribunal's ongoing and retention of jurisdiction and the inherent flexibility in the exercise of its remedial powers, also with the dialogic approach undertaken by the parties and the class action, notes that this panel, or supports that this panel has the jurisdiction to assess the final settlement agreement and assess its ability to satisfy the whole compensation decision and all the compensation orders. Now, my friends from Canada and the Commission have chosen to challenge this panel's jurisdiction. And they note a couple of things in their arguments. They would suggest that, first of all, the compensation order is final and therefore it can't be changed. This panel is functus officio, which requires a rejection of the FSA, and the motion itself is premature, and they use all these issues. The AFN would state that the Commission and the Caring Society are wrong on this point, and I'll quickly provide some context to that. First of all, with respect to the compensation order being not final, both the Commission and the Caring Society assert that the compensation order and the compensation framework are final documents. The AFN strongly disagrees with that. As we note in this panel's compensation order, this panel stated at 270, as part of the compensation process consultation, the panel welcomes any comment, suggestion, and request for clarification from any party in regards to moving forward with the compensation process and the wording or content of orders. For example, if categories of victim survivors should be further detailed or in a new category added. In the compensation framework decision, this panel stated, the panel retains jurisdiction on all its compensation orders, including the order in its ruling, and will revisit its retention of jurisdiction as the panel sees fit in light of the upcoming evolution of this case or once individual compensation has been completed. Despite our friends' assertions that these orders are final, the AFN would note that both the compensation order and the framework order do lack clarity in a number of areas, which require parties to come back to this panel and seek clarification, which obviously means ongoing litigation before we're even in a position to starts awarding compensation payments to any individual. For instance, the Caring Society admits that this panel has never defined the meaning of in care in relation to children removed from their homes and placed in non-ISK funded placements. As a result of this acknowledgement, it's quite possible that this group of children might not even be eligible for compensation under the CHRT process. To correct this potential problem or this gap in the order, Caring Society suggests maybe further negotiations are warranted regarding the status of that class of individuals, while suggesting that AFN's negotiation process in the final settlement agreement is completely prohibited. It is a contradiction with respect to what they are saying. Clearly, if we can negotiate more provisions, more compensation parameters within the CHRT process, and that's not functus or the orders are not final, clearly there is an issue with the Caring Society and the Commission's logic. In supporting its arguments, the Commission and Caring Society rely on Walden, Papaloi, and Lake Babin First Nation to argue that this panel cannot reconsider its orders. There is a big difference between those cases and this case. In those cases, it either dealt with an employment issue or a group of employees and their employer. It is easy in employment cases, so yeah, you should offer a job a description or just offer a job posting to an individual. That would be something that would be final. That is quite different from what we have here with respect to the extent of the discrimination and the various factors and realities First Nations children and families face across Canada. We would encourage this panel to disregard those cases with respect to supporting the issue of finality of this tribunal's orders. Clearly, they are comparing apples to oranges. Furthermore, the AFN's request to vary compensation orders does not amount to deciding matter differently. We would argue that the compensation package does satisfy this tribunal's orders, and if there are areas where there is divergence, that there may be need for this panel to vary the orders to address the existing evolving needs of First Nation claimants. And we have done that within the final settlement agreement. The final settlement agreement is implementable, will be implementable very quickly. We would note the final settlement agreement, I should say the compensation order itself, is in no way a final document or in a final state. Give me 1 second, I'm trying to find
Mr. Watke?
Yes, I'm just looking for a passage.
No, I'd like to jump in just for a minute.
Sure.
This is something I'm not sure was addressed in any submissions. If I may be wrong, but if we leave aside the judicial review at the Federal Court of Appeal, if we leave aside the settlement agreement, and let's say for a moment that we would move ahead with the tribunal decisions that were affirmed by the federal court, who in your view would have to rule on any contentious issues arising out of the compensation process?
Yes, thank you for that. I mean, in our view, it would be the tribunal. The fact that the federal court has endorsed this panel's ruling, we would argue that what the federal court was actually doing was endorsing this panel's jurisdiction to make the order. I don't think there's nothing in the federal court order that precludes or prohibits this panel from making further decisions with respect to compensation. Much as the same way with the Federal Court of Appeal, Canada is challenging this panel's jurisdiction again to order compensation. That is quite different from this panel actually exercising its authority.
Thank you.
And, we would also argue that, if the Caring Society and Commission are right and the orders are final, we can't make any further changes to that. We can probably clarify certain things, but we can't make any additional changes. Under the process right now and where we are today, we still have much work to do, and we cannot actually pay compensation to anybody. And that's where we would argue that, obviously the panel has jurisdiction to continue to make rulings with respect to compensation. Because clearly if the Caring Society and the Commission are right, no further changes to the orders could be made. And we are obviously not in a position right now to actually award compensation. So I think it would sort of create a frustration in the process and make the compensation orders unworkable. So that would be the caution of the AFN. Clearly, this panel has jurisdiction, and we would argue that it has the ability to continue to exercise that jurisdiction.
Can I just ask a question on that same line? Mr. Wadke, given what you've just said about your argument about the retained and continuing jurisdiction of the panel and the broad powers that we have and the flexibility that we need to show, particularly in difficult and complex situations like this, and the fact that, as you say, that it's not final, does that allow us, in your view, in considering your motion, to go beyond your request? And that is, if you say you wish us to endorse, we say we endorse, but we have certain conditions, or we wish to make certain revisions. If that was in our mind at all, I would guess that if I'm understanding your comments about the breadth that we have in continuing to have jurisdiction over compensation, that would allow us that latitude as well. Or do you take the position that our only decision can be either to, let's say, with respect to your first alternative, to endorse the settlement agreement, the FSA, or to dismiss the motion? Is there some latitude there, given what you've said about jurisdiction?
Yeah, so the way I look at that is, the panel does have jurisdiction, and with respect to the current motion before this, it's obviously the AFN's position and desire that we get a yes or no response. With respect to, clearly we would argue this panel has the ability to endorse the motion, the compensation framework, and grant the motion requested by the Assembly of First Nations in Canada. But with respect to making suggestions with respect to the agreement itself, we do note that this agreement is, deriving from the class action. It is meant to settle both actions, but it is in the class action process. But secondly, we would also ask the panel to consider the fact that the settlement agreement is built on a number of stepping stones, for instance, key areas. So if we start interfering with the settlement agreement, they may have unintended consequences of unraveling certain processes that are built upon that process. So we spent months articulating and putting together the agreement and making sure that all the provisions work. We would argue, to answer your question, yes, we think you would have that ability to make suggestions. but we would encourage you to think about the consequences and the possible unraveling of the settlement agreement if that were to occur. And secondly, we also have the Federal Court of Approval process pending next week. And they will be looking at the decision of this tribunal, whether or not it endorses or not. That would have another snowball effect with respect to that proceeding. So we are confident that the agreement itself fully satisfies the agreement, deals with all the issues that this panel has looked at, provides more compensation to individuals, includes more individuals into the process. There are some deviations, which my friends will speak to, my colleagues will speak to, but in the end, there is a lot riding on what we have produced after careful thought and using a dialogic approach. So we would encourage this panel to be mindful of that.
Thank you. I appreciate your comments, but what I take away from that is that at the end of the day, while you're not urging us to do that, you are acknowledging that we would have the authority to do it, correct?
Yes, I would say this panel does have the authority to make recommendations, yes.
Okay, thank you.
Yeah, with respect to moving, any more questions before I move on?
Mr. Woodkey, sorry again. While we're asking questions, I think it's the right timing for me to just clarify one point. In terms of this compensation agreement, do you see this as resolving the long-term reform portion or not? I didn't read this in your submissions, and I just wanted clarification on this. That long-term reform is separate and that nothing in the agreement will resolve the long-term portion at this point?
I would say, yes, thank you for that question. At first, they were linked, and meaning one depended on the other. We were able to convince our friends in Canada to sort of decouple the process so that they could stand alone. But I would note that it is part of the overall $40 billion package. So if compensation doesn't go forward for whatever reason, I'm not saying it won't have an impact, but it possibly could have an impact. And perhaps Canada can provide more context to that when we do their submissions.
Thank you.
Moving on to the compensation framework and finality. My friends from Caring Society and the Commission suggest that the compensation framework itself is final. The AFN obviously disagrees with them. For instance, in section 2.1, the compensation framework will be managed by a central administrator that is agreed to by the parties. Section 2.5, the parties shall develop an implementation and distribution guide. Section 3.5, the parties and the central administrator shall develop an opt-out process. Section 4.2.2.2, further guide, and this is speaking with respect to the definition of essential services recommended by a professional, that must be interpreted in a manner that the claimant has an ability to provide proof of assessment, recommendation, and contemporaneousness. And here, the operative part of that paragraph says further guidance on this matter will be included in the guide reference in 2.5. Section 4.2.4.1 is part of the guide. The parties will agree on a process for Canada to provide information. Section 7.5, the parties and the central administrator shall develop a guide, a post-claim period guide. 9.4, second level committee will rely on standards including any timeframes proposed and approved by the parties. 12.2, parties will continue to work in a collaboratively develop criteria to identify and expedite potentially complex claims. Section 13, This deals with the whole further development of the framework. Section 50.1, the framework is intended to provide overall guidance to facilitate the compensation process. As noted above, the parties will continue to work on tools that may provide more precision and guide the implementation of this agreement. 13.2, the parties will discuss the development of these tools with the Commission and with the interested parties as appropriate in keeping with the scope and status of the interested parties' proceedings. The APTN would submits that these passages in the framework agreement, the compensation framework, highlight how much additional work will be needed in the context of rolling out compensation. This document, the compensation framework, was ultimately 25 pages long, reflecting some of the most basic outlines on how compensation will be assessed. It's more of a statement of principles than a fleshed out compensation plan. In effect, there's still a lot of work the parties will need to do to actually get this process up and running and get the compensation rolling out. The parties themselves have undertaken work needed to expand their framework, developing a realistic and First Nation-led approach to compensation reflects human rights principles. The APTN submits that the compensation framework is nowhere near a final state, despite what our friends from the Caring Society and the Commission assert. Considerable work still remains with respect to the compensation process. The APTN is also troubled by the Caring Society's positions regarding kinship care placements, step parents, and a broad inclusion of every individual placed into care. The term kinship and various custody arrangements in the compensation framework is insufficiently defined. It's ambiguous and overly broad. The panel has not provided any direction on this issue in the interpretation with respect to the compensation framework. We would argue that such a broad term obviously would obviate the parties' efforts to give clarity to the eligibility criteria for compensation. So overall, APTN submission is that the Caring Society and the Commission are wrong. The orders are not final. They reflect this panel's ability to come back to issues, look at the orders, provide more clarity, provide more context, issue new orders. That's all within the jurisdiction of this panel. If the Caring Society and Commission are right, obviously this panel would not be able to do any of that, and the order stand as is, and compensation will never be paid. Now, with respect to the panel being not functus, my friends from the Caring Society and the Commission basically use the doctrine of functus officio. Basically, it states that there is a need for finality. The APTN argues that the final settlement agreement does bring finality to this process. It incorporates what is necessary for compensation in the coming months once we do the approval hearing and we roll out the compensation framework or the claims process, the compensation claims process. We will be in a position as of hopefully January to begin paying our compensation. Much more quicker than what we have with the current CHRT process. I've already explained our submission or our position on finality. Clearly, the orders are not final, so in our submission, the whole issue of officio functus doesn't apply to these orders. So they are not final orders. We would argue that the doctrine of functus officio does not apply to administrative tribunals in the same way it applies to courts. And the Supreme Court of Canada noted this in the decision of Chandler at paragraph 862. Supreme Court of Canada noted that justice sometimes requires a doctrine to be applied in a more flexible and less formalistic manner. So if the orders are final, the AFN would argue that officio functus still doesn't apply because of the nature of the complaint, the rights of individuals, and the discrimination that they endured requires that we take more than a technical approach to providing compensation and remedies to individuals. And that flexible approach, of course, would be the final settlement agreement and the approval of it. So we argue that the case law clearly states a recognition that there are situations where the doctrine of officio functus should be applied more flexibly. And the case law points, with respect to where it applies, clearly there is no right of appeal in certain circumstances. In that circumstance, the tribunal can reopen the decision to grant relief that is not available on appeal. If there's a right to appeal, only to the point where justice may require the reopening administrative decision in order to provide relief that would otherwise be available on appeal. In this case, the Canadian Human Rights Act does not provide any appeal rights. So therefore, we would argue that the remedies that we are seeking, the remedies that the AFN in Canada are bringing forward, would require a less formalistic approach, and they should be adopted by this tribunal. In the case of Federal Court Case Canada versus Simpson, at paragraph the Federal Court of Appeal states, as here, appeal from the decision of the tribunal is only weighed by judicial review, then justice may require that the tribunal be allowed some latitude. The AFN would argue that the Caring Societies and Commission's argument do not stand up to the scrutiny with respect to Justice Fable's decision in the judicial review. The fact that the decision was not, this panel's decision was not disturbed on judicial review is not a determinative factor. In Miram versus Royal Bank of Canada, this is in our factum, we note that the Human Rights Commission had, in this case, stood for the proposition where the Human Rights Commission had rejected a complaint and a decision was upheld on review. The complainant subsequently sought reconsideration from the Commission in light of new developments. The Commission rejected the complaint again on further judicial review, argued that the Commission was functus. In that case, the Federal Court disagreed. The Federal Court stated at paragraph 22 in that decision, in Clayson Transport, Hunter, Mr. Justice O'Reilly found the Commission had the power to reconsider its decision, even though no specific statutory provision provides for such reconsideration. Justice O'Reilly found that under the Canadian Human Rights Act, the Commission clearly possessed a very broad discretion to screen and process claimants, which supported the conclusion that it would reconsider decisions. Paragraph 24, moreover, Mr. Justice Pinka stated in the following in the Chandler case. To this extent, the principle of functus officio applies to decisions of administrative tribunals. It is based, however, on the policy ground, which favors finality of proceedings rather than the rule, which is developed with respect to formal judges of a court, judgments of a court, whose decisions but subject to a full appeal. For this reason, I am of the opinion that the application must be more flexible and less formalistic in respect to the decision of the administrative tribunals, which are subject to appeal only on a point of law. Justice may require the reopening of administrative proceedings in order to provide relief which would otherwise be available on appeal. Accordingly, the principle should not be strictly applied where there is indications of an enabling statute that can be reopened. So we would argue that Our friends, positions and submissions with respect to officio functus are not applicable in this case. The ongoing jurisdiction that this tribunal retains, the fact that some of the orders are not final, clearly provides this panel with the jurisdiction to grant the motion and relief sought by the Assembly of First Nations in Canada. We would also submit that where cases involve human rights, functus officio doctrine plays a diminished role. And we put a case in our faction regarding British Columbia Court of Appeal, where the British Columbia Human Rights Council of Human Rights had jurisdiction to reconsider decisions simply by virtue of the fact that there was a human rights tribunal. The federal court had repeatedly held that Section 53.2 of the CHR grants this tribunal the power to reserve jurisdiction on certain matters in order to ensure that remedies ordered by the tribunal are not forthcoming, are forthcoming to complainants. In this case, in our motion, the failure to accept the settlement because it falls short of some aspects of the order, while farly exceeding this tribunal's orders in other areas, would prevent remedies from being forthcoming to the complainant. We have other submissions in our written submissions dealing with more aspects of the functus argument that we would rely on and encourage this panel to consider. So in light of that, we would argue both the Commission and the Caring Society are wrong with respect to the submissions and finality orders and the application of officio functus officio. Based on that, the APTN will argue that this panel's retained jurisdiction is not only limited to procedural matters, nor is the panel's jurisdiction to vary orders limited to adding further specificity to categories of compensation beneficiaries, as the Commission argues. We also note that the Commission makes these arguments without any case law to support their propositions. The Commission also cites Doucette-Bordeaux versus Nova Scotia, where the Supreme Court states that the rules of practice in the provincial courts enable courts to add or vary their orders as to carry them out in operation, or to even provide other or further relief originally granted. This decision, to the extent it applies to CHRT in the context of this tribunal, actually supports the panel's jurisdiction to grant other and further relief sought by the AFN on this motion. So that being said, with respect to the jurisdiction component, the AFN would argue and submit that this panel clearly has the jurisdiction required to grant the relief sought by the Assembly of First Nations in Canada. Now, with respect to evaluating the FSA, the Final Settlement Agreement, this panel obviously, we would submit has jurisdiction to do that. We would note there appears to be no direct precedent accounting for the parties to the CHT proceeding and negotiating a final settlement agreement for compensation outside the tribunal process. But this court case, this matter before this panel has, in many areas, had not had any precedent or roadmaps with respect to relief that was being sought. As I mentioned earlier, this panel is bold. It has created new law, and it has respectfully requested that the parties consider negotiations. The AFN in Canada followed that process and took that advice from this panel, or took that direction. We would argue that in assessing the final settlement agreement and its endorsement, that the tribunal continued to be cognizant of how its remedial jurisdiction affords a flexibility and broad statutory direction. It even submits that the exercise of this panel's discretion in the context of considering the endorsement of the FSA is only constrained by the fact that it must be exercised in a reasonable and principled way further to the CHRG regime. And we would argue that the compensation framework settlement agreement actually does that. It provides compensation. In many ways, it will provide the compensation that would be ordered by this tribunal at a minimal. Children will get more money in certain circumstances, as well as other individuals. The APTN submits the question before this tribunal must be focused on whether the FSA is reasonable in principle and satisfies its compensation orders. We would argue that several factors should guide this tribunal's consideration with respect to that assessment. First of all, if the settlement agreement meets the tribunal's and the CHRA's objectives in relation to compensation. It accords with international human rights principles. It is a continuation of a dialogic approach. It is a product of reconciliation being grounded in a First Nation-led negotiation. Litigation risks in consideration should also, there be litigation risks and consideration should the tribunal not endorse the FSA. We may be back in litigation. We may be back before this panel for a number of months or years dealing with compensation issues. And of course, our process was informed by the representative plaintiffs. Now, barring perhaps I can just have 1 second to converse with my colleagues if I might hand it off, or I might have further comments in a couple seconds.
Yes.
Or perhaps this might be a good time to break for lunch. It is 12:21.
Okay. We're going to try to make up for the time this morning that we lost. So an hour will be what we'll take for a lunch break, if that's agreeable for everybody. I think that would be that will help us to make sure that we make up for the time. So we would be back at 1:20.
All right, thank you.
Oh. Ms. Clark, you had a question?
Yes, thank you, Madam Chair. I'm just wondering if AFN Canada have the amount of time that they will be taking throughout the rest of the day. Would just be assistive to know, just in terms of timing for the rest of the day, the order and timing on submissions for today, if that's available to the parties.
Sure. Mr. Whitkey?
The AFN have more clarity on that question after lunch, so perhaps we can speak to that when we get back.
That's fine. Thank you. Have a good lunch.
Thank you so much.
Recording stopped.
little break was beneficial for everyone, and we will be continuing the AFN submissions. So before we broke, there was a question from council, from the Caring Society, trying to understand how long the AFN still had to provide, to present their submissions. So I will just ask the AFN council to respond and continue their submissions.
Yeah, I think, can you hear us?
Now I can, thank you.
Great. Oh, I gotta do 2 sides? An hour and a half.
Okay, thank you.
Or sorry, it's an hour and 45 minutes.
Okay. Whenever you're ready.
Okay, Ani Bojo, Wajgesnado Kwe Makwado Dem, Chiging Donjaba. My spirit name
Recording
is
in
Spirit of the
progress.
Deer Woman. I'm from the Bear Clan, and I'm from Chiging First Nation, on the largest freshwater island in the world, Manitoulin Island. My English name is Diane Corbier, and I'm legal counsel for the AFN in this matter, and also for the AFN and its representative plaintiffs in the class action. I thank the Mississaugas of the Credit First Nation for always welcoming us to this territory in what is now known as Toronto. Good afternoon, panel members, Mark Childen and Lustige, I think. I'm sorry if I'm saying it incorrectly. Counsel for all parties, and as Mr. Wapke said, most importantly, the survivors and victims of Canada's discrimination. Now, Gabo Corbier has been working with the parties in the tribunal since 2009, and we send greetings from Mr. Nawagabo, who's been working with the tribunal and the panel for many of these years. Mr. Wapke, as an AFN negotiator and myself, have been going across the country to First Nations regions, providing information and answering questions since 2020 regarding the negotiations on compensation, the agreement in principle reached on December 31st, 2021, and the final settlement of June 30th, 2021. To set the context and understand the responsibility that we bear as Anishinaabe people and as lawyers, and to do the required work by the final settlement agreement. I thought about the testimony of Elder Bobby Joseph, who was before this tribunal on January 13th, 2014. And going across the country, Mr. Wapke and I and the AFN team heard much of the pain, the suffering, and the hardship you mentioned and acknowledged this morning, Chair Mark Childen. We heard from Chiefs Representative plaintiffs for the Assembly of First Nation, and we heard generally from those who have been directly impacted by Canada's discrimination in the Child and Family Services Program and the narrow application of Jordan's Principle. Many talked about this in painful details, just like you heard from Elder Bobby Joseph. Elder Bobby Joseph gave testimony about his own personal painful experience, and he sort of projected what he thought we would go through in trying to resolve the child welfare problems and the Jordan's Principle problems. Similar to Elder Bobby Joseph, many told us they want to move beyond the pain. Like him, we heard many discuss and share their desires to move on in their reconciliation journey. They all recognize that this final settlement agreement is not perfect. And we heard that. We also heard from a regional chief from Manitoba the other day. He asked everyone to put their hand up and say, who has ever seen a perfect agreement? No one did. But it's also reconciliation is not perfect. And it's a process, and it is a process with no formula. We have heard so many want to get compensation to these children and families who have suffered so greatly. They've been waiting a long time. We also heard from many that they're not just about compensation. We heard from survivors talking about long-term reform to them is just as important. And if you go to our website, you will hear from these survivors talking about the work they've been doing to bring long-term reform. We received many requests of when is the compensation coming? Thousands of requests. People are waiting. I want to thank Chiefs of Ontario and the Anishinaabe Nation and the Federation of Sovereign Indigenous Nations for working with us and their important support of the First Nation right holders impacted by this final settlement agreement. I can also share the deadline to object in the federal court has passed, and there is not a single objector to the final settlement agreement registered. I share this in the context for the work we have been doing to implement the tribunal's orders in coming to this final settlement agreement. It has taken a lot of work and a lot of discussions with survivors and First Nation leadership. So as Mr. Watke has indicated, I am going to summarize some of the aspects of the settlement agreement. And so that is at it starts at paragraph 116 of our book. And I mean, you can follow along because I'm not going to read it all. I'm sure you've all read your materials, but I just want to highlight some points just to emphasize a point. And as Mr. Watke said, we know that survivors are watching and they will watch this. And we want to continue to demonstrate that we are moving forward on the reconciliation journey. So in grounding the whole final settlement agreement, in approving the compensation framework, the tribunal stated in its framework decision at paragraph 36. And to me, I'm going to explain how this grounded all of our work. The entire compensation process, and I quote at paragraph 36, the entire compensation process is a part of the compensation remedy that is focused on a process that considers not just the financial compensation, but also other relevant factors such as creating a culturally safe and appropriate process to provide compensation in light of the specific circumstances of this case, including historical patterns of discrimination, the vulnerability of victim survivors who are minors or adults who lack legal capacity, access to justice, a clear and equitable process across Canada, and the avoidance of unnecessary administrative burdens. The parties to the final settlement agreement, assisted by the knowledge and experience of the Assembly of First Nations and Canada's representatives involved with the development of the compensation framework, took a similar approach in drafting the final settlement agreement. Throughout the process, efforts were made to incorporate and, where possible, expand on the terms of compensation orders in alignment with the Canadian Human Rights Act principles. The parties were predominantly successful in their efforts, as reflected in paragraphs 116 to 177 of our factum. We can say as well that we heard many submissions in coming to the final settlement agreement, including those that you're reading in your materials. We have considered everything in coming to this final settlement agreement, but we do have more to come. Throughout the parties, as Mr. Watke stated, I will focus my submission on our work to incorporate and expand on the terms of the compensation orders, and my colleague Jeff Culper will present where we necessarily deviated. The provisions of the final settlement agreement are substantive, complex, and nuanced, and the preamble clause is a reflection of the quote that I I shared with you from the tribunal decision. It demonstrates and grounded and guided us to what the tribunal directed needed to be done for the claimant to access compensation in a safe process in keeping with access to justice and avoiding administrative burdens for survivors and victims of Canada's discrimination. The final settlement agreement at Exhibit F to Janice Sabaglia's affidavit at pages 8 to 9 of the final settlement agreement expressly reflects within its preamble the parties' desires. And I could say to the panel, I'm going to quote directly from there, so you don't need to turn it up if you want. But if you want me to wait, I will. So, and I quote, "This is what has guided us. We needed to ensure that the claims process administered in an expeditious, cost-effective, user-friendly, culturally sensitive, and trauma-informed manner." And you will hear this so many times from our side of the table. We use these words over and over again to demonstrate our commitment to the survivors. And we are to safeguard the best interests of the survivors who are minors and persons under a disability, minimize the administrative burden on survivors and victims, ensure culturally informed and trauma-informed mental health and cultural support services, as well as navigational assistance are available to survivors, and provide for some class members or subsets of class members to receive direct compensation while ensuring that those who do not receive direct benefits may receive direct benefits through a CyPray fund, and I'll explain that further. Now, in your materials, we start out when we talk about the settlement quantum. The actual quantum of compensation contemplated within the final settlement agreement is fair, reasonable, and principled, as it meets and arguably exceeds the objectives of the compensation decision and related compensation orders. The $20 billion in total compensation is significant, meaningful, and will have substantial impact on the lives of the survivors of Canada's discriminatory conduct. We heard this across First Nations regions in Canada. Again, similar to what we heard from our chair this morning, no amount of money will right the wrongs that these individuals have endured. And the tribunal recognized that as well. And we heard that from the chiefs and leadership as we went across the country. They can go back to Canada's discrimination from treaty time to the present day, and they can describe all of the wrongs. And they all resoundingly agreed that no amount of money would ever be enough. However, we have also heard that the compensation under the settlement agreement could be life-changing for many individuals who have been marginalized and harmed by a discriminatory system, and some form of vindication for the discrimination that they personally suffered. Yes, the $20 billion is fixed. To the best of the parties' knowledge, this amount is more than sufficient. For the class, which will include individuals covered by the tribunal's orders and exceed in some respects, which I will explain, and is more detailed in our factum and materials. I want to talk about the compensation mechanism briefly. In terms of the compensation mechanism, the final settlement agreement reflects a reasonable and principled approach derived from lessons learned. We will hear that as well, because as we went across the country, leadership was talking about past settlement agreements over and over again and wanting to ensure that we've learned from them in this process. And it's also consistent with the compensation decision and the compensation orders. The parties sought to adopt approach, which was similar to the common experience payment provided for in the context of the Indian Residential Settlement Agreement, as endorsed by the Tribunal, which minimized evidentiary requirements, focused instead on shared discriminatory experiences of the survivors. The AFN view is that this is a culturally competent, First Nation-led and trauma-informed compensation process that is in the best interest of First Nations children and families at the heart of the compensation decision. This amounts to an effective remedy, a core human rights principle. This approach is reflected in the final settlement agreement for all classes, and this was really important to the Assembly of First Nations. There is a presumption in favor of qualification for compensation, a low burden to establish entitlement, and minimal evidentiary requirements. So many people told us that they thought other claims processes were intended to trip them up, to minimize their compensation, to lessen their compensation, to make them feel worse about even coming forward to seek compensation. So, while they also want proportionality amongst the claimants in the same class requires some information upon which to base distinctions. I recall when they talked about people with disabilities being induced to leave their community to be able to get care. They had to leave their family. And resoundingly, when we talked about that, everyone agreed that that was one of the most egregious things that happened in all of these cases. That a disconnection from Indigenous people from their communities is the greatest harm. So the primary mechanism for this is to rely upon objective factors that require minimal verification wherever possible. This assessment process is the opposite approach from the independent assessment process associated with the Indian Residential School Agreement. And as you've probably read, has been criticized for re-victimization of survivor claimants. I'm also a bencher at the Law Society of Ontario, and we talked and we had to do some studies on the conduct of lawyers re-victimizing claimants in that process. And as we were going out across the country, a lot of complaints about lawyers' conduct in supporting claimants. So the compensation provisions of the final settlement is my next approach. The causes of action within the context of these class actions drew from the compensation decision, being rooted in Canada's discriminatory funding of the First Nation Child and Family Services Program and its narrow application of Jordan's principle. So we're seeking compensation for an expanded timeline for the survivors who suffered comparable discrimination to that identified within the compensation decision, but now from 1991 onwards, being the date that Directive 20-1 established the discriminatory First Nation Child and Family Services Program. The class action contemplated 6 unique classes of individuals for whom compensation was sought and can be summarized very similar to the work we did with the Tribunal. And I'll just summarize this, for the people watching. For the removed child class, our First Nation individuals who were removed from their homes between 1991 and 2022 as minors, while they or one of their parents were ordinarily resident on reserve. The removed child family class is defined as parents, grandparents, or siblings of the members of the removed child class. Only the caregiving, biological step and adoptive parents, or the caregiving, biological and adoptive grandparents in this class are entitled to direct compensation. Jordan's principal class is comprised of all First Nations minors living anywhere in Canada between 2007 and 2017 have a confirmed need for an essential service and faced a denial, delay, or service gap with respect to the needed essential service. The Trout Child class is comprised of all First Nation minors living anywhere in Canada who between 1991 and 2007 had a confirmed need for an essential service and faced a denial, delay, or service gap with respect to that needed essential service. So for the Assembly of First Nations, taking these programs back to 1991 made sense. As I stated earlier, when we were going across the country, the leadership could talk about, you know, the colonization, the discrimination, and all of their hardships right back to treaty time. So for us, this takes us even further back in this claim. And I just wanted to share with you, this claim is named after the two children of the plaintiff, Zacchaeus Joseph Trout of Cross Lake First Nation. Sine and Jacob Trout both had Batten disease, a rare genetic neurological disorder that normally begins in early childhood. Jacob and Sine suffered from a lack of adequate services until the end of their short lives, and both passed away by the age of 10. So the Jordan's Principal and the Trout family class are defined as parents, grandparents, or siblings of the members of the Jordan's Principal class and the Trout child class, and only certain caregiving, biological step and adoptive parents, or caregiving, biological and adoptive grandparents of the members of the Jordan's Principal and Trout class who suffer higher impact within the class are eligible for direct compensation under the final settlement agreement. Now, I want to get into more detail about how each of these classes we have complied and it's not even complied, it's that we reflect and we've aligned what we've done. We were guided and grounded by the guidance we were given from the compensation decision. So I'm going to just talk briefly about it, and my colleague, Mr. Tauper, he's our math genius. He will get into a little bit more details about the numbers. But let me just go through it generally because it's important. The final settlement agreement provides that all of the removed child class, which includes those individuals who are eligible as removed children under the compensation order, will receive a minimum of $40,000, reflecting alignment with the compensation decision and related compensation orders. The final settlement agreement also significantly expands both the number of eligible children eligible to receive compensation and the amounts that they will receive. The first way in which eligibility is expanded is through the class period. I mentioned this earlier. The class action was not bound by the same limitations that the tribunal was concerned about. As a result, the parties to the Class A action were able to begin the class period on the date at which the discriminatory funding system was implemented by Canada, at the inception of Directive 20-1, April 1st, 1991. This is significant, as children removed from their families and home prior to 2006 were also victims of a similar discriminatory system that is the object of the compensation decision. A corollary is that more family members who were caregiving parents or grandparents for these children will also be compensated as a result of the expanded class period. The second expansion relates to whether a child was placed outside the community. The compensation decision awarded compensation to children who were placed outside their homes, families, and communities. For the final settlement agreement, a child was placed outside their home, but placed within the community, and the placement was funded by Indigenous Service Canada. That child is eligible to family members who qualify for compensation under the FSA. I can assure you that going across the country, First Nations are concerned about either placement reality, and they are wanting justice about this. There are other class actions that are going through the system to address the off-reserve children that were in the Child and Family Services programs. So beyond expanding eligibility, the linking of placements to ISK funding serves at least two principal purposes. First, it links the harm that was caused by Canada to the incentivization of placements, because Canada's discriminatory funding model prioritized removals over preventative measures, as you know all too well. Second, it facilitates the identification of children who were removed from the data received from ISK. A final settlement agreement priority with respect to the removed child, and lessens the need to consult provincial and agency records. And I assure you, in spending all this time and coming to the final settlement agreement, we didn't have any expert that was able to tell us that we would be able to find reliable, dependable data in the provincial and agency records. So it has to be the ISK data for the Child and Family Services program. The third expansion is the amount of compensation that a removed child will receive. The enhancement payments address the tribunal's observation that other means are available to obtain compensation beyond the statutory limitations of the Canadian Human Rights Act and that $40,000, which was the highest amount the tribunal could order. And our panel reminded us of this morning, and it was insufficient to compensate for the egregious harm that the class suffered, as the panel summarized. The factors used to enhance the payments made to the removed child class members are listed in Article 6.03 of the final settlement agreement. And it's important for people to know that there was a broad discussion across the country of coming to the following: the age at which the removed child class member was removed for the first time, the total number of years that a removed child class member spent in care. Some of them aged out. The age of a removed child class member at the time they exited the child welfare system. Again, this is aging out. Whether a removed child class member was removed to receive an essential service relating to a confirmed need. I mentioned that earlier. It wasn't in this process, but many of our representative plaintiffs said it had to be. And whether the removed child class member was removed from a northern or remote community. And again, I give a shout out to Anishinaabe Nation, who now, since being engaged in implementing the tribunal's decisions and orders, have established what we call the NARC, and they are working with many northern and remote communities on the realities. And this final settlement agreement is intended to address some of those very important northern and remote community realities. The number of spells in care for a removed child class member, and/or, if it can be determined, the number of out-of-home placements applicable to a removed child who spent more than 1 year in care. The plaintiff's experts, and based upon our review of the agreement in principle and the final settlement agreement across regions, have accepted each of these factors as reasonably objective proxy for the level of harm that the class members suffered. While the specific amounts are not set out in the FSA, and I gave you a couple of examples, it will be obvious that some will be the max. Those who aged out of care, those who were induced into care for the rest of their life because they were trying to access an essential services and were denied access to the most important thing, their culture, their community, their language, their spirit, etc. Not all survivors will be eligible for an enhancement payment, but survivors who are eligible for the highest levels of compensation could receive more than triple the amount awarded by the tribunal if this system for the weighing of the enhancement factors is adopted by the plaintiffs with the assistance of experts in the claims process. The enhancement factors permit proportionality, and as I remind you, we said that this was really important to the survivors that we talked to based upon individual impacts above the 40,000 threshold, while minimizing the risk of causing trauma to claimants. The information used to apply enhancement factors will be obtained where possible from ISK data. We needed to be able to help them pre-populate their forms, if you will. A caring hand with navigators to help them fill out the forms. This method relieves class members of the burden of testifying, being subjected to interviews, obtaining documentation on their own. We already heard when we were going across the country from chiefs that their citizens were calling and saying, help me get my records, I need to get this compensation. So if there is a gap in the ISK data, it may be supplemented by information provided by the class members themselves. The AFN contends that these new entitlements and factors align with the stated objectives of the compensation process as noted by the tribunal. Canadian Human Rights Act principles in relation to recognizing and vindicating breaches of victims' rights of discrimination and equates to reasoned and principled expansion of the compensation order. Again, the removed child family class. The compensation available to the removed child family class begins with the same objective as the removed child class. A minimum of 40,000 to eligible class members, in line with the expansion of compensation to removed children back to 1991 at the advent of Directive 20-1. Compensation has comparably been expanded for caregiving parents and grandparents of these children, well beyond the timeline contemplated by the tribunal compensation orders. The tribunal ordered that compensation was limited to biological parents, and if one or more grandparents cared for the child at the time of the removal rather than the parent, then the biological grandparent would be eligible to receive compensation. The final settlement agreement, based on going across the country, expands and hearing the views of our citizens, expands the category of eligible caregivers to adoptive parents, step-parents, and adoptive grandparents. However, in the event of multiple claims from biological parents, adoptive parents, and grandparents, the FSA awards compensation according to a list of priorities. Biologic parents come first. Again, as I mentioned, the establishment of the child class and the trout family class, after a notable way in the final settlement agreement, sought to build and expand the tribunal's compensation decision and related compensation orders, was by way of inclusion of the trout child and family class. As previously noted, the trout child class is comprised of all First Nations minors living anywhere in Canada who, between 1991 and 2007, had a confirmed need for essential service and faced denial, delay, or service gap with respect to that needed essential service. The final settlement agreement extends compensation to these First Nations children who suffered discrimination regarding essential services prior to 2007. The final settlement agreement for this class contemplates a minimum amount of $20,000 in compensation for those most impacted as a result of the denial, delay, or service gap of a needed essential service, and up to $20,000 for those who have suffered an objectively higher level of impact as a result of the same. And again, the final settlement agreement extends compensation to the caregiving parents, grandparents of the child class member who have experienced the highest levels of impact and may be entitled to some level of direct compensation. While those children did not meet this threshold, would not receive direct compensation, but would still be entitled to access indirect benefits by way of the CPRE fund. And again, I'm going to come to the CPRE fund separately because it's really important to the Assembly of First Nations. The Assembly of First Nations contends that the inclusion of the Trout Child and Family classes is significant, as these children and their families were again subject to the similar discrimination of those contemplated in the Tribunal's matter. Their inclusion aligns with the Canadian Human Rights Act principles, as it ultimately affords those survivors with the potential for redress in relation to Canada's historic harms and an opportunity that may not have otherwise been available given they occurred prior to any legal recognition. The remedies available to the Tribunal, quote, attempt to make victims whole and prevent the recurrence of the same or similar discriminatory practices, end quote. As such, the AFN submits that the expansion to include these clauses should be viewed by the Tribunal as a reasonable and principled expansion of the compensation decision and related compensation orders. Again, I'm now coming to the CPRE fund, which some people have termed indirect compensation, but I still think it's direct. The final settlement agreement establishes a CPRE fund, which will be endowed with a minimum of $50 million. There's an opportunity for people to invest with charitable receipts. So this fund may actually grow. The CPRE fund's primary purpose is to benefit class members who do not receive direct payment under the terms of the final settlement agreement. This includes all siblings of the removed child class and the Jordan's principal class. The CPRE fund is another means by which the final settlement agreement seeks to expand on the compensation decision and related compensation orders, recognizing that discrimination at the heart of the compensation orders was felt by all immediate family members of the removed children and those who experienced a delay, denial, or service gap in the context of Jordan's principle. One of our representative plaintiffs is not getting compensation because she's a sister of a removed child class member. But she is firm and steadfast in support of this. She's happy that the CPRE fund is there. She's happy that her other family members will get compensation. And she even risked, and you can watch her videos, she has risked losing the support of her adopted family through committing to this process. So our survivors have been really committed to this. The CPRE fund will be designed with the assistance of experts and has the objective of providing culturally sensitive and trauma-informed supports to survivors, which may include, again, one of our representative plaintiffs worked with the First Nations Youth Informed Care Network. And we grounded, the Assembly of First Nations grounded the CPRE fund in their recommendations. So it may include family and community unification, reunification, connection and reconnection for youth in care and family in care. It's not just the youth that are talking about this need. We heard it across the country. Facilitating access to cultural programs and activities and supports. We consistently heard about that connection to community and on the land and how important that is, and they wanted to make sure that that funding was already there. Facilitating access to transitional supports such as safe and accessible housing, life skills, and independent living, financial literacy, continuing education, etc. Facilitating access to navigational supports for Jordan's principal class members and families who are not eligible to receive post-majority care and are not covered elsewhere. A national First Nations Youth in Care from Care Network may also be established, which we're really hopeful for, and that people will invest in this, which could include national or regional networks for sharing best practices and updates, engaging in advocacy, and providing recommendations on policy. Again, grounded in the guidance we received from the Tribunal decisions, the Tribunal was clear in its compensation orders that a compensation process should be culturally safe and appropriate and take into consideration the vulnerability of our survivors. The implementation of previous class action settlements has resulted in First Nations experiencing many negative impacts on their well-being. I myself have heard from survivors of the residential school IAP process over and over again about the horrors that they experienced through that process, even through the hearing. People, you know, committing suicide, you know, people throwing up, people who were sober and clean for years and years, you know, spiraled after the IAP process. So the implementation, a fundamental lesson learned is that in class action proceedings addressing historical wrongs to First Nations, the process must be designed to avoid re-traumatization. In particular, the experience of survivors in the, as I mentioned, in the independent assessment process are the horrors I speak of. Consistent with the compensation orders, the final settlement agreement establishes principles to govern the claims process intended to minimize the trauma. As noted by the federal court, if compensation is done in a manner that minimizes re-traumatization, it may also help to bring closure to a painful past and value which cannot be understated. The AFN would submit the final settlement agreement's efforts to minimizing of trauma is a critically important consideration in evaluating the final settlement agreement satisfaction of the compensation decision, as it is in the best interest of First Nation children and families who are at the heart of the tribunal proceedings. The parties to the class action have meaningfully considered and incorporated the principle of minimizing trauma into the final settlement agreement. The shared intention and core principle is clearly reflected in the language of the FSA throughout, and which states the claims process is to be administered in a culturally sensitive and trauma-informed manner. For example, the FSA notes that the administrator, who has already been appointed by the court, again, a reminder, the horse has left the barn. There's huge expectations for compensation, and we're already starting to administer and meet milestones for these survivors to get their compensation. The administrator has been appointed by the court, and we have set out the guidelines for the current administrator. On the recommendation of the parties, an administrator has been appointed, and their duties include developing and implementing systems, forms, guidelines, and procedures for processing of claims and appeals, developing procedures for payment of compensation, receiving settlement from trust funds, ensuring First Nation participation and trauma-informed approach. That is key to us. In carrying out its duties, the administrator is governed, again, like I said, by other various principles, ensuring the claim process is cost-effective, user-friendly, culturally sensitive, trauma-informed, and non-traumatizing. You also heard about the claims process and the distribution protocol. The final settlement agreement contemplates a process that it minimizes the administrative burden on survivors and recognizes the importance of cultural safety, health, and wellness. The process must minimize trauma as well. The FSA outlines both the principles and process relating to the distribution of compensation, which will inform the development of the final distribution protocol. The claims process and distribution protocol will be developed with the input of the administrator and the parties to ensure it is aligned with the principles of the final settlement agreement. And the final settlement agreement contemplates that AFN and Mushuan Class Council may seek the input from Caring Society as well as other experts and First Nation stakeholders in the design and implementation of the distribution protocol. We have already assured the First Nation regions we will be coming to further explain the claims process and distribution protocol before December 20th, 2022. Again, I think I might be going over time, but the supports that the tribunal said was so necessary have been fully built into this agreement. This includes mental health, cultural supports, and trained navigators who will promote communications, provide referrals. We have a lot of lessons learned. Again, this too is First Nation-led mental health and wellness. At all times, the phone line will be made available in a culturally safe manner. And we thank you, panel, for reminding people of the Hope for Wellness line, that those supports are already in play for the people that will be accessing the compensation. The AFN submits that the parties' efforts reflected in the FSA aimed at minimizing trauma, including ample supports contemplated therein, both align and build upon the efforts contemplated within the compensation orders and are an important consideration for the tribunal assessing whether the FSA satisfies its compensation decision and compensation orders. Throughout the settlement negotiations, AFN advocated for robust supports to be available for the claimants during the claims process, and they have included and detailed all of these all of these supports in a framework. Given that the survivors who are now children will be able to claim compensation once they attain age of majority, Canada will be funding these supports for approximately 21 years. And those supports expressly recognize the generational nature of settlement. As a result, a child who was removed their own home in March 22, as of March of 2022, the end of the eligibility period, will receive an equivalent support to a child who is eligible to complain immediately upon settlement approval. These supports will continue from the point that survivor seeks information on the application process and will continue throughout. Such extensive supports are not readily available within the context of litigation. It is the final settlement agreement that allows for this important feature. Outside of the supports framework, Canada has agreed to provide funding to the Assembly of First Nations, and relatedly, the CPRE Fund will provide further supports and benefits to children and families. The AFN submits that the significant scope of supports contemplated under the final settlement agreement are reasonable and principled and accord with the best interests of the First Nations, children and families at the heart of the compensation decision and related compensation orders. Since signing the final settlement agreement, we are furthering this work with experts and First Nations stakeholders, again, including Northern and remote First Nations. First Nations are expecting to continue this important work after a settlement approval hearing process with the Tribunal and the Federal Court. This is my last point about what's so important in the final settlement agreement. The administrator will provide ongoing report with respect to the implementation of the final settlement agreement and on systemic issues relating to the implementation of the claims process with a review to addressing such issues. A First Nations-led settlement implementation committee overseeing the final settlement agreement. A First Nation-led settlement implementation committee will consist of a majority of First Nation representatives, and they will oversee the claims administration process, address systemic issues that may arise. Their oversight of the whole claims process is crucial to the successful implementation of the parties' shared intention. The parties intend that the SIC will facilitate an appropriate level of flexibility in the claims process and be able to respond to systemic issues. We heard numerous complaints across the country about the inflexibility of the claims process. So they are empowered to engage experts in trauma, community relations, health and social services to provide ongoing advice on the implementation. This First Nation-led settlement implementation committee will also be responsible for bringing motions to court, etc. And they will be in place for over 20 years following the approval of the final settlement agreement. A First Nation-led process is required by our First Nation, and it's consistent with their right to self-determination. They want to control what happens to their people. The AFN submits, like Elder Bobby Joseph, this process is ready and will be First Nation-led, and we're ready to move on to next steps in the pursuit of reconciliation. We're already in the implementation mode, armed with the support of the compensation decisions and compensation orders. Decisions have already been made by First Nations in improving the agreement in principle, the final settlement agreement. And the federal courts has already approved some steps. And as I have stated, people are frustrated. They're expecting conclusion on compensation and are waiting to move to those important next steps that Elder Bobby Joseph talked about, moving on to reconciliation. The final settlement provisions meet or exceed the compensation contemplated by the tribunal and its compensation decision and related compensation orders, and supports the endorsement. He's on mute.
Sorry. Yes, I just have one question. Thank you for your information. It's very helpful. So my question is this: when you were doing this consultation during the course of the negotiation, which I think you referred to as sort of a consensual thing that wasn't necessarily perfect, did you encounter, did you reach out to, did you speak with anyone, any individual who put forward concern that the FSA would remove any rights that they would have had under the current regime? In other words, were there people that spoke to you about the concerns that they might have about reductions in coverage and elimination in coverage has been alleged by the Caring Society?
We, like I said, we have one person who's a rep plaintiff, and she's not getting any compensation. And through the class action, she might have got compensation. So everybody we spoke to understood the process. They all agreed that the priority was to get compensation to the children, for example, as opposed to the families. This was a very difficult process. And as I also said, there is a complaints process at the federal court, and we have no objectors registered. I hope that's helpful.
Thank you.
You need a quick break? I can start. Do you need a break, or Mr. Cowper's ready to start to keep things going?
So that's fine. Please go ahead. I'm sorry if the document for the hearing in recess is appearing, but we're okay to continue.
Can you hear me?
Yes.
So thank you very much. My name is Jeff Cowper, and Mr. Butke and Ms. Corbieri have asked me to address the section of the factum, which is paragraph 59 to 72. And my purpose in dealing with that section, and perhaps before I do it, let me adopt the territorial acknowledgement that my colleagues have given, and as well acknowledge the debt that we owe to those who have brought us here. In general, let me say that my purpose of going here is to demonstrate how the terms of the FSA are faithful to the CHRT as they have said, but more particularly that the variations which may occur, and some of them are in the deal, but some of them depend upon the numbers of claimants against the fund, are principled, reasonable, and supported by the feedback and the principles received from the leadership of First Nations and the communities across the country. And let me say, as a non-Indigenous person, that you, with respect, are seeing First Nations leadership happen before you. The FSA represents decisions which at every turn have been informed by the First Nations leadership and the input received from the communities. And let me say that at each turn, decisions have had to be made. So do we accept a fixed sum of $20 billion? The leadership had to decide, do we turn away from a process that might engage years and years of individuals coming up and claiming monies with an uncertain total, or do we take leadership and say, this is an amount which is implementable and is manageable and is in the best interest of everybody concerned? The decision was made to accept the $20 billion after many, many months of negotiations. And the First Nations leadership looked at the budgets that are reflected in the FSA, looked in the procedures that are reflected in the FSA, and made decisions about how to make that implementable, manageable, and to ensure that there would be funds available for the members of the class. So I'm going to come to decisions, but I want to emphasize that once you make the decision that $20 billion, which is a staggering amount of money, but has to be managed, once you make that decision, then the decisions that you see reflected in the very careful terms of the FSA, the budgets for the various classes, the relationships between those budgets, the priorities between class members, priorities between classes, the principles of proportionality, what to do with potential surpluses, what to do with reallocation of budgets that become available, what to do with potential adjustments, how to manage it. All of those are decisions which flow from the decision to adopt a class action settlement vehicle in the interest of everybody, in the interest of all the people whom we represent. Once you do that, those decisions are inevitable and they're necessary, but they're reasonable, they're principled, and you ought to have confidence once you read the materials that the $20 billion is more than sufficient to render justice for the people who we're fighting for and seeking to move on to a settlement mode and away from the litigation that is taking us here, as well as potentially ongoing. And effectively what I'm saying is that the class action settlement vehicle, and that's my following role here, and I'll try to be quick about it, is it permits the First Nations here to take control of the process, as Ms. Corbier said, and to deliver the benefits of the settlement to their children and their people. But it must be noted that the approval by this tribunal and by the members is actually necessary to move on. And I'm going to express that explicitly. But one thing that I think is critical to this hearing is we can't move on until approval. What's remaining to be done requires the approval of the final settlement agreement, and I'll specify specifically why, but let me give you an example. For example, in Jordan's Principle, and the Carey Society has criticized the state of development of Jordan's Principle, the expert advice is you can't go further until you pilot and test with people how the processes are working so that you don't expose people to re-traumatization. You test whether or not it's simple enough. You test the reliability of the answers. Well, we say, with respect, we can't do that until and build expectations of a distribution that may not happen. And so we've gotten to the stage where not only do we know where we're going, which is what we do, but we need the approval to get there. So with that, let me say that and I'm going to make a point Ms. Corbier vastly overstated my abilities with math in her comment on me being a math genius, which immediately fills me with terror that I'm going to make additional mistakes in my submissions. But let me just try to deal with some simple math. And the point I'm going to make is this, and that is, notwithstanding the filings that oppose your approval of the settlement, you should have a full confidence that the amounts that have been settled are very generous and provide the First Nations leadership with the ability to distribute generous benefits that are consistent with both the spirit and your orders in this matter. And let me give you a couple of examples. So for example, and this may be the hardest one, we don't know for certain how many people fit within the Jordan's Principle category. That's part of what the piloting and testing is about. We've budgeted $3 billion, $3 billion for that. That may be far more than is necessary to meet the claims, or if the claims exceed the number that we expect, we may have to make adjustments. That's what the agreement's provided. But to be clear, the best estimate we've been able to obtain is that there was 65,000 claimants if we have 100% of what we estimate showing up for the claim. We actually have several $100 million on top of that total to provide a margin of safety. And so, just so, and I'll make this point briefly, you ought to conclude that there's substantial evidence here that the parties worked to develop workable, generous budgets that are within the framework of the orders you've made. Now, and I'll say this in general, which is one of the directions that we've received that's reflected in the FSA, is that we should plan for 100% of the people who are eligible to receive benefits. And you may know from other class actions, the plan's actually almost the opposite, that people can show up, that nobody expects there to be 100% distribution. Our plan is to meet 100% of the people out there. You can see how the plan to ascertain them, to pre-populate claims, the work that's been done to identify where they are, using the ISK data, is all aimed at not requiring people to just volunteer, but to find them, to help them, to pre-populate, as Ms. Corbier said, with respect to removed children, and in many cases to provide navigators, to provide assistance, to provide professional assistance, to ensure that 100% of the people who fit within the classes and the claimants in the FSA receive benefits. So with respect, you ought, and I'll deal with it in general terms without giving the specifics, with respect to the removed child category in the budget, there's a very substantial room, well over $1 billion, for enhanced payments to the removed child category. And so we can't be 100% certain, and the FSA must provide for guardrails in case our expectations are met with different numbers substantially, because we must, to be responsible, ensure that there is funds available for everybody over the whole life of the settlement. That's why you'll see these references to actuarial advice. Deloitte's administrator has to administer and assess this. It's going to require an ongoing professional oversight and administration under the direction of the Settlement Implementation Committee, which is, of course, First Nations led. So what I'm saying there in general terms, and you can see this in the materials, is I say you should find that there's a substantial reason to believe that the budgets which have been established by the claimants and counsel for the claims in this case are substantial, they're reasonable, and they will provide for substantial benefits. They may be far better and larger than we expect, depending upon the numbers of claimants that produce claims. So if you then go to 178, 179, and I can build on this, and I'll try to be economical with my time. Let me say that firstly, as you see in 179, that the necessary consequences of the fixed settlement are part of the factors which required the terms that we've spoken to. Secondly, the complexities of the compensation of the Jordan's principal class, which is compounded by the lack of data. We have an estimate of that, but there's been thousands of hours spent on this question, and especially in relation to Jordan's principle, when you go back in time into the trout class, we are not certain how many people will come forward and say, I've had a service gap, and this is what the service gap has meant to me, and this is what you ought to take into account in your process. We're building the process to enable that to happen, but there's uncertainty as to what that will happen. We've sought to be as generous and broad as we can, and we've provided a budget, as you can see, of $3 and $2 billion. There's $5 billion provided for there in the trout and the Jordan's class, but we have had to provide a means by which that can be both delivered and also other classes protected. So if you go to 180, and this is just repeating the priorities which are reflected in the terms, such as the priorities over children, there's a theme here from First Nations leadership, which is if you have to make a choice, if 5 years from now, 10 years from now, the administrator has to make choices, we want those choices to ensure that the children come first, and that if any benefits have to be reduced, they're benefits that are coming to others than the children. So if you go to 182, and I'm dealing now for the rest of my submission with some of these choices that are reflected in the final settlement agreement. And the first one's really at 182. And there are two matters or two areas where the removed child family class, this is the removed child family class, may deviate from the compensation framework, depending upon the amount of claims, the number of claims. Firstly, we provided for compensation up to $60,000 for caregiving parents and grandparents. In other words, we haven't provided for multiples of $40,000 by the number of children. So if it's 4 children, it's still capped at $60,000. And secondly, if there's a higher than expected number of eligible caregiving parents and grandparents, there's an adjustment mechanism to the base compensation. And essentially what's happened there is we've recognized the impact of multiple removals, which is something the tribunal recognized, and we've recognized a measure of proportionality, but we've protected it against uncertainties with respect to the number of parents, caregiving parents, and grandparents. And as best as we can determine, we can't, and Mr. Wutke set forth the professional assessment of how many parents, caregiving parents and grandparents there are, but there's some uncertainty around that. We have to have a way in which we assume that the agreement can be, or we can be assured the agreement can be implementable within the plan to provide compensation for everybody. So if you go over to 184, you'll see that, for example, and that's the adjustment provision which I've footnoted at 252. Okay? So, and one safety valve, as Ms. Corbier said, is we've provided for a CPRE fund that may in fact make up for any person who would otherwise be eligible but who hasn't made, and because of the numbers, received as much as we had hoped for. So the final comment I'd make here is that although we dwell on, because the agreement written by lawyers has to cover negative contingencies, let me say one positive contingency which arises from accepting the fixed sum, and which can, I think, be understated and it needs to be recognized, which is the payment of the compensation trust fund of $20 billion then starts earning money. And so in the life of this whole settlement, there's going to be, and it's not an ascertainable sum, but there's going to be extraordinary amounts accrue to the unpaid amounts as they go from the first day it's received, which are going to be able to be distributed as part of the benefits in this case. So that is not possible in the normal kind of situation where you turn up and the defendant pays what they agree to pay or what the adjudicator finds to be paid. It's a central virtue of this claim that the First Nations, having chosen to accept the money, then are in control of the investment and earning returns on those funds, which are of course going to be conservatively invested under professional management. And you may know there's an entire section dealing with the investment committee. There's professional actuaries involved. But I just want to emphasize that not only are we providing for, in some ways, additional draws on the fund, the central thing is we've provided for the fund to grow. It's going to grow from the moment the money's received, and then as payments are made out, there's still going to be amounts going on the balance. And that's why you'll find in the agreement provision for what happens if we have surpluses. Because one of the positive contingencies, we may have surpluses. And so what are the priorities for surpluses? What are the priorities if, in fact, the budget's more generous than necessary? How do we reallocate that? All of those choices, which are reflected in the priority sections of the compensation provision in the final settlement agreement, were made and decided and informed by First Nations leadership. And that's, in my respectful submission, a virtue of using the class action vehicle and using this means as opposed to a traditional payment on claims tendered approach. So if you then go to the Jordan's Principle compensation, which my friends at the Caring Society dedicate a good deal of attention to, let me make several general submissions. Firstly, their criticism of the state of development with respect is misplaced and is unfair to what First Nations leadership has decided to do as set out in Janice Savalia's affidavit. The feedback from both First Nations communities and the many experts who were consulted here was, do not provide a straitjacket in which Jordan's Principle claimants are going to be excluded who you would want to have included. Learn from the people who you are seeking to benefit and don't provide for a provision which is precast. Many class actions, you show up and say, this is going to be it, and anybody who doesn't make it, that's just a decision we've had to make. The leadership here said, no, we're not going to do that. We're going to learn from both the experts in our communities, and we're going to move forward on the basis that the final approach to Jordan's Principle, which is going to be subject to court approval as part of the distribution protocol in December, is going to learn from the experiences, the feedback, and the actual experience of trying it on with our people. That's only possible if you approve the settlement agreement. We can't go into the communities and ask a representative population of people to try this out without an approved settlement agreement that we can act upon. And so, with respect, the Caring Society's criticism of the generality of the principles is misplaced because they fail to recognize that this train is moving. We have a framework, we have draft questionnaires, we have expert reports, we have other forms which are going to be embodied, piloted, tested, refined, and finalized, and then are subject to the approval of the court as part of the distribution protocol in December. So I say with that, with respect, you ought to be satisfied that the processes which are being responsibly carried out are going to summarize and come up based upon that input and then be subject to approval by the court in December. And so you should be satisfied that that's the right process, that the wrong process would be to say, we want you to have a finalized form today, which if people don't meet, they're excluded. We want to try this out. We feel we have to try it out. We have to pilot it with the people who will be affected. And that includes not just who's in and who's out, but what is the effect of people participating in the claims process? What assistance do they need? What are the instructions that navigators need to receive in order for people to participate in this claims process for Jordan's Principle to feel they've been fairly done by? What are the services which people report as being essential? We have a definition of essentiality, but we haven't adequately been able to find out in the actual communities themselves what their lived experience has been with respect to essentiality. We need to learn from that, and that's the proposal that we have to go forward on that basis. So if you go to 188, you'll see that I summarize some of that, and I refer to the observations in the Tribunal's own orders that there had to be responsibility, reasonable accommodation, and flexibility with respect to the Jordan's Principle. And so if I can say, if you go to 190 and following, you'll see that what we sought to do specifically in Jordan's Principle is to adopt objective criteria, to adopt a reasonable definition of essential services, and to ensure that both denials, delays, and service gaps are covered. And so if you go over to 191, and I think I've said this to some extent, what we have is a very substantial budget for that. And the math is everybody we currently estimate to be a member will receive the full $40,000. So if you then go to I'm going to skip by a little bit because I think what I've said in 192 are that the elements of the claim are being faithful to both what the tribunal has observed and what the community has told us of the need to not traumatize claimants, to avoid individual trials or hearings, and to be respectful and culturally appropriate. So you'll see over at the top of 192, carrying on page 65, there are other matters in turn, which are similarly protective and are going to be followed in the living out of the Jordan's principle process. So let me say, if I may, in relation to the two categories of Jordan principle claimants, which are the subjects of some criticism. The decision made by First Nations leadership here was that we needed two categories because we needed to ensure that the principle of proportionality in Jordan's principle was implementable and that the people who are most harmed will receive more than $40,000, at least $40,000, but more than $40,000. And secondly, with respect to the people who are not in the category of most injured, if I can put it that way, that we can provide for a generous eligibility for the remaining population, which based on the budget may mean that they each receive $40,000 depending on the number, but it takes into account in an adjustment way what happens if more than those people show up. So in some ways, we can afford a more generous eligibility than might have been contemplated under the tribunal's order, but we provided safety for what happens if the numbers are greater than we expect through the process. So I'll summarize where we're at in the development of that process, and I do that at 196 to 200. But you should know, and this has been a huge effort of a large number of experts, a lot of work, that basically what's being developed is a constellation of supporting processes that surround the claimant and that assure us that we're finding all the claimants, we're informing all the claimants, and we're assessing it in a responsible way. So we have a framework for essential services which has been finalized. We have draft questionnaires which are being followed, and we have provisions for exceptional circumstances. So basically where we've gone is we've identified examples of essential services. We've identified examples of those most affected, and Ms. Corbier eloquently spoke of some of those. And we've also identified the areas we need to test in respect of other essential services, which we think may have a material impact on claimants deserving of compensation, but not to the extent of the higher category of compensation. Now, is that a responsible decision? In my respectful submission, of course it is. That flows from the understandable, and I say completely appropriate, direction of First Nations leadership that we must provide for more than $40,000 for those individuals who have been most affected by the discrimination reflecting an historical failure of services to these children. I think I should deal with the departure from the deviation or departure from the Jordan's Principle family class. And that, put very simply, we have a budget of $2 billion, and we have limited that. We expect that only caregiving parents and caregiving grandparents will be determined in the significant impact to be eligible for compensation. You'll see that in Article 6.06.16. That was a very deliberate decision that flowed from the general direction to provide a priority for children. And if we didn't provide that, then our assessment of the budgets is that the budgets would be at risk. And at risk because of payments to family members rather than children. So we followed that into the terms of the FSA to ensure that the children were protected. And let me say, that is a fundamental compromise, as we say in paragraph 209, which the First Nations leadership made in order to achieve the settlement that's before you. So two things I maybe should, if you go to page 70, I've dealt with exclusion for abuse. That is, in our view, consistent with the spirit. It is express of your order. It's expressed slightly differently, and it's informed by the desire to avoid trauma. And I won't speak to it in detail, but I commend the paragraphs 211 to 213 to you. So then the one final area where I think I should deal with it is in relation to estates. And the Caring Society is concerned about the differences between the treatment of estates in the FSA and those in your order. And in essence, we have departed from this, and the answer is very simple. Again, children must be given priority. And in respect of the most affected children, in our respectful submission, the FSA provides for direct compensation to them rather than compensation to the family members. And so we think it's both appropriate that the submission and treatment of claims to family members be subject to that change. Fundamentally, we have to safeguard, as I say in paragraph 215, the compensation for deceased members of the child class and the child classes themselves. I don't think I need to speak on the issue of release. I will say in general, though, that from a class action perspective, the agreement here is an agreement between the parties. To the extent that all of these choices have been made, undoing the choices has consequences for other terms and other matters. And so I'll add my voice to Mr. Wutke's voice to say that this is a constellation of choices that have been made by First Nations, which we believe is in the best interest of the children and the people involved. And we commend to you and ask you to approve it in its entirety, and that we then, as a community, the communities affected can move on to execute upon settlement, seek approval in federal court, and move on to finalize the claims process. Those are my submissions, subject to questions you have.
Thank you. Member Lustig, do you have any question at this point?
What I've heard you say with respect to areas where the divergence resulted in a potential claimant under our regime, the current tribunal regime, receiving less, those decisions, shall we say, were made on the basis of prioritization in favor of children, applying proportionality with respect to the gravity of the situation, and the uncertainty of certain numbers. Would that sort of capture where those divergencies in your explanation of them were made?
Yes.
And that would also include overall, I would imagine, the fact that you were dealing with $20 billion, not 21 or 25 or some other greater sum of money. That was also, it must have been a factor as well, correct?
Absolutely, because it's a factor of unknown size, but we know whatever it is, it's going to be huge because it's whatever percentage we earn on $20 billion. And so we have confidence that that growth will allow us to do more than $20 billion would permit us. And whatever it is, it's going to be much more, and that can fit into the formulas and the budgets and the adjustments that are provided for in the agreement.
But as I mean, one of the main principles that I've heard, and I think everybody agrees with, is that the money should be paid as soon as possible, and that the process should be as quick and as expeditious, but as fair as possible, so that it's not held up by further litigation. It's not held up by doing things that now may not be necessary in view of the work that you've done. But given that, isn't there going to be a fairly large, once the 20 billion is put in trust, and I assume it's all in trust at one point, the earning life of that sum of money will quickly be taken up by the fact that hopefully you're paying people out fairly quickly, and a lot of them. No?
So we've looked at that, and I think the short answer is it of course is interest on a declining balance. It's on a declining fund, and we're of course committed to paying it out as quickly as possible. But bear in mind that under the terms of the FSA, the funds will remain in the trust fund until people are of the age of majority. And so that's for many people going to be a substantial period of time. And we've provided for a time adjustment for payment, but there are going to be billions of dollars in the trust fund for an extended period of time. I think I'd say it the other way, if I may, Member Listic, which is to say, if we only have $20 billion for 6 months before we pay it out, we're already going to be making, if we make 5% on $20 million, the extra amount will make the ability of the administrator and the settlement implementation committee make their job much easier. There's going to be substantially more freeboard, if I can put it that way, than we have in 20 billion. So no matter how quickly we pay it out, because of the fact we're dealing with children, you're going to have very substantial balances earning interest over significant periods of time. I think that's our projection. And so we didn't want to over promise either the communities or the tribunal of that. But as you know, when you start with 20 billion, even if you take off and reduce that as quickly as we can, you're still going to have very substantial amounts of money earned on the balance.
And interest rates are going up.
Yes. Well, I'd like to say we planned for that, but we didn't. But we hoped for that. We hope for increased interest rates really through the life of on behalf of the members for some period of time. Exactly. 1% interest in rates on $20 billion, as you know, is a huge amount of money.
Thank you. Appreciate your answers.
Thank you for your question, Member Lustig. Thank you to the AFN for all three councils. There's more coming. I'd like a break.
Yes,
I'm sure that other people would want a break. Yes, Mr. Whitkey?
Sure, I'll need about 5 minutes. I can do it after the break, so that's fine.
Well, what's your preference?
We can do it after the break. If you need a break now, that's fine.
Okay, so we'll take 15 minutes. Thank you.
Recording stopped.
everyone. I hope this break was helpful. So we ended with Mr. Wadke, who had another 5 minutes. So Mr. Wadke, are you ready?
Yes, I am.
Please go ahead.
Thank you. So just to sum up our submissions, the Assembly First Nation would like to submit that, the final settlement agreement is reflective of fundamental customary and human rights discourse. It follows Article 7 of the UN Declaration on the Rights of Indigenous Peoples with respect to forced removals. It speaks to Article 8 regarding forced assimilation. It's taken into account the UN Covenant on the Rights of the Child. And these standards that are in these international instruments are part of and embedded into the settlement agreement. I would also note that this agreement reflects the exercise of self-determination domestically. The panel has expressly stated in the past that it respects First Nations rights to self-determination. And in its compensation decision at paragraph 267, it says, given that the parties and interested parties of the case are all First Nations, except for the Commission and the AGC, they all have different views on appropriate definition of a First Nation child. It is paramount that this form part of the discussions on the process of compensation. The panel reiterates that it recognizes First Nations human rights, Indigenous rights, self-determination, and self-government. Where we are in this process is the AFN is highly respectful and thanks the panel for its assistance and direction in getting us here. As I mentioned at the outset, we would have never gotten here without this panel's orders, its forward thinking, and the laws that were pronounced in changing the legal landscape. That all made this very possible. But we're at a place where potentially once the settlement agreement's approved, First Nations will begin to administer the compensation agreement. It may very well end this tribunal's jurisdiction on compensation. We do have a robust system that's in place. It'll speak to issues, any novel matters that may come up. There'll be processes for that. So we are at a process where we believe that the First Nations are well equipped at this point to take it over. We would also suggest that the final settlement agreement embodies the constitutional promise of reconciliation. Canada has committed to recommend to the Prime Minister through the settlement agreement that they provide a public apology to First Nations children and victims of Canada's discrimination. And this whole process is a product of beneficial negotiations with Canada Mission and the AFN. First, there will be significant First Nations presence with respect to self-government. I mean, with respect to the oversight of and administration of the settlement agreement going forward over the next 21 years. AFN will be there. We're not going to be leaving our citizens behind. We will be with them hand in hand, as well as the First Nation leadership across Canada. You'd also state that the FSA reflects a dialogical approach. Again, we engaged with Canada. We looked at the compensation process, trying to make this clear as possible. And finally, we have representatives, participation for our representative plaintiffs, who are fit many of the categories. Now, I'd like to respond to one question that panelist Lustig has asked whether or not we heard it from anybody about any misgivings with respect to them not getting the full benefits. I can advise that the representative plaintiff in Jordan's principal family class is Yonovan Masawage. Yonovan is the estate and son of the late Maureen Beadle. Yonovan fully supports final settlement agreement, even though he does not receive compensation, either as a sibling or as his mother's estate. He's always focused on the kids, and they come first and foremost. He supports the final settlement agreement and swore an affidavit in the federal court to this effect.
In conclusion, we would note that the AFN, again, was the only party to seek individual compensation be paid to victims of discrimination. As a result of that, it was always the AFN's burden to come up with a compensation scheme that meets the interests of First Nations children and victims. We encourage this panel not to displace the self-government process or self-determination process and the wills of First Nation communities across Canada with respect to the approval of this final settlement agreement on the basis that two non-rights holding organizations do not support this final settlement agreement. In sum, the AFN is requesting a declaration from the Tribunal that the final settlement agreement fully satisfies the terms of the Tribunal's compensation decision, compensation framework, and any other compensation orders. In the alternative, that the Tribunal amends its compensation decision, compensation framework, and the other compensation orders to conform to the proposed final settlement agreement. And in either event, if the Tribunal's endorsement of the FSA or a variation of the compensation decision do conform to the terms and therefore remain contingent on the federal court's approval on the terms of the final settlement agreement. Those are the submissions of the Assembly of First Nations. Thank you.
Thank you very much. We will now hear from Canada Council.
Thank you, Chair Marshallton and Member Lustig. It is Paul Vickery for the Attorney General of Canada. As you know, Canada joins together with the Assembly of First Nations in seeking an order that the Compensation Final Settlement Agreement satisfies this Tribunal's compensation order and framework and all associated compensation-related orders. As we have said in our reply to the submissions of the Caring Society and the Commission, it is in the spirit of reconciliation that Canada has sought to resolve through a negotiated process the claims for compensation raised both before this Tribunal and, of course, in the federal court class actions. Together with the Assembly of First Nations and Mushume Class Council, Canada's Council have engaged over the last 22 months now, first in a very extensive ongoing negotiation, first under the federal court guidelines in a mediation led by the Honorable Leonard Mandamin, and then in intensive negotiations under the guidance of the Honorable Murray Sinclair. This led to the signing of a final settlement agreement on June 30th of this year, and now brings us before this Tribunal, seeking the Tribunal's endorsement of that final settlement agreement. We join together with the Assembly of First Nations and Mushume Council in asking that this panel does endorse the final settlement agreement, which is the product of our negotiations, as satisfying the Tribunal's compensation orders and framework. As you have heard, and as is noted in the affidavit of Dr. Gideon, our joint objective in the negotiations was to reach a comprehensive settlement of all of the issues raised in the class actions, and at the same time to resolve the compensation issues related to this Tribunal's compensation orders. Canada's commitment, however, went beyond the compensation issues, as it also at the same time committed to negotiations on a separate track toward the long-term reform of the First Nations Child and Family Services Program and Jordan's Principle. As I believe you're aware, a separate agreement in principle was reached in that regard And we can advise, of course, that discussions toward a final settlement of those extremely important issues is ongoing. Now, in approaching the negotiations as to compensation, Canada's first guiding principle was that any settlement should be First Nations led. We therefore agreed from the beginning that the settlement would be designed by the plaintiffs and not by Canada, and specifically that the administrative scheme, the distribution of the settlement funds to be paid by Canada, and the breakdown of payments among the classes would be in the sole discretion of the plaintiffs, subject, of course, to court approval and necessarily subject to this panel's approval. It was agreed after extensive negotiations that Canada would pay the unprecedented sum of $20 billion to fund the compensation. And I would point out that it was a negotiated amount, and that indeed Dr. Blackstock of the Caring Society was present during the final stage of that negotiation when the $20 billion figure was arrived at. In addition to the $20 billion, Canada committed to pay significant funds to fund supports for claimants over the expected 21 years of operation of the settlement. Under the terms of the final settlement agreement, in addition to that, Canada will pay the costs of giving notice to the class, the costs and disbursements of the administrator, the costs of the third-party assessor, who will be charged with an appellate function to determine that the administrator's decision in terms of accepting or denying a claim was in fact appropriate. We will in addition pay the costs of the trustee of the trust fund, the auditor, and any expert advisors or consultants retained by the Settlement Implementation Committee, as well as in general the cost of administration of the trust, the costs of the operation of the dispute resolution process provided by the agreement, and legal fees, which will be dealt with separately through mediation and through a court application if that becomes necessary. And it's significant, I think, to point out that this means that there is no prospect whatsoever of legal fees impacting on the amount of compensation agreed, the $20 billion. That is exclusively to be devoted to compensation for the claimants. All of these requirements on the part of Canada are set out at Article 3.04 of the final settlement agreement. Now, our intention in agreeing to all of this was to ensure that the entire amount of $20 billion, together with the very considerable interest which would be expected to be earned from investment of the fund, would remain available to the claimants. And that is a pivot point for everyone in terms of the design of the final settlement agreement. It was very important to maintain that principle throughout. Dr. Gideon notes in her affidavit that this level of funding, which I submit is fair to say is unprecedented, demonstrates the government's recognition of the extent of the past harms suffered by First Nations children and their families, and its commitment to redressing those discriminatory practices. It is entirely consistent with Canada's overall seeking toward reconciliation with First Nations that it has committed to the provisions of this final settlement agreement. Now, although the design of the settlement was in the sole discretion of the plaintiffs, there was nevertheless vigorous debate among Assembly of First Nations Council and officials, Mushume Council, various experts, Canada's Council, and experts retained by Canada at each stage of the negotiations. And that occurred because each party was encouraged to put forward its views and equally to respond to the views of others. And as Dr. Gideon notes in her affidavit, each of the parties was fully able to develop and voice their positions. Ultimately, we were able to achieve agreement on all of the issues which were presented, and I can assure you there were a multitude of issues which were addressed by the parties, first during the course of the mediation before former Justice Mandamin, and secondly, in the intensive negotiations before the Honorable Murray Sinclair. Now, the counsel for the AFN has spoken of the emphasis which was put on ensuring that the claims process will be administered in an expeditious, cost-effective, user-friendly, culturally sensitive, and trauma-informed manner, which will minimize the administrative burden on claimants. Canada is and has been fully supportive of that approach and is of the view that the agreement will in fact deliver on those objectives. And that is very important to us. The language of the agreement, whether dealing with the role and responsibilities of the trustee, the administrator, or the Settlement Implementation Committee, is intended by all parties to entrench those concepts in the agreement. And that was a very deliberate effort on the part of all parties to ensure that those criteria illuminate, if I can put it that way, the implementation of the settlement on an ongoing basis. The structure of the Settlement Implementation Committee, in particular, is also intended to ensure that the settlement is truly First Nations led and First Nations focused. As Diane Corbière, counsel for the AFN, has noted, 3 of the 5 members of the Settlement Implementation Committee will be First Nations, and they will therefore be in a position to ensure that the committee remains culturally and trauma-informed in its approach to the administration. Again, that is in our submission, a very significant aspect of what was intended and what was achieved. Similarly, the instructions given to the administrator, and that can be found at Article 5.01 of the final settlement agreement, are deliberately intended to reinforce this approach by reiterating the need for a culturally and trauma-informed approach. Now, quite significantly in our submission, the continuing supervision of the settlement by the federal court, together with the obligations which are placed on the trustee, the administrator, and the Settlement Implementation Committee to report to the court on a regular and ongoing basis, will ensure that there is strong continued oversight of the settlement. As you may know, the courts view their primary role in supervising a class settlement as being that of protecting the interests of absent class members, as they're referred to, given that the vast majority of class members are not and will never be before the court directly. That means that any proposition put to the court regarding the settlement will be viewed by the court through the lens of protecting the interest of the class members. That is indeed their sole concern in reviewing the operation of any class action settlement. Turning to the substantive provisions of the agreement, counsel for the AFN has made it clear, of course, that it's not suggested that there is a literal one-to-one correspondence between the terms of the settlement and the provisions of this panel's compensation framework. Counsel for the AFN have described the points of variance in some detail and have advised as to the motivation which led to those variances while staying as true to the underlying principles enunciated by the panel as possible. It is clear in our view that if negotiated settlements are to be fostered and encouraged, as has been repeatedly suggested by the courts, there must be an ability among parties to make reasonable compromises. If a literal one-to-one correspondence with existing orders were required, then it would necessarily become virtually impossible to negotiate any overall settlement touching on the orders. The plaintiffs and Canada focused throughout their discussions on the need to reconcile two potentially conflicting objectives. The first being to provide compensation which is proportional to harm, while at the same time minimizing the potential for re-traumatization through requiring claimants to provide detailed evidence as to their personal circumstances and experiences, which in past settlements, it has been learned, leads to potential re-traumatization of the claimant through the very process which is intended to provide them with appropriate compensation. So it's a self-defeating mechanism, if you will. This settlement agreement, by its terms, avoids that sort of exposure on the part of the claimants to any potentially traumatizing process. The input required of the claimants is kept as minimal as possible. And all of the parties were and are of the view that that is a particularly important aspect of the settlement. The list of enhancement factors, which are proposed as proxies for harm regarding the removed child class, and this can be seen at Article 6.02 sub 3 of the FSA, in our view, will provide the administrator with a reasoned basis for determining entitlement to enhanced payments with a view to providing proportional compensation. And of course, the purpose of creating proxies for harms is to avoid the necessity of requiring direct evidence from claimants with regard to the actual harm experienced. So what was intended and in our view was achieved by the parties in putting together the settlement was to find a number of factors which all could agree would in all probability lead to a more severe potential harm to the individuals. And you have heard those factors described by AFN counsel. In our view, those are appropriate factors to operate as proxies for harm, thereby reducing the potential for re-traumatization. Now, you have also heard of the decision of the plaintiffs to design a system of weighting those enhancement factors based on the input of experts. In our view, having that input from experts should ensure that the distribution protocol, which will set out the detail of the process and of the eligibility criteria, will achieve its objective of producing an evidence-based and principled method of recognizing the varying experiences of claimants and providing proportional compensation without the need for an intrusive process. Now, in our view, it is important to realize that the distribution protocol, which is scheduled to be presented to the federal court for approval on December 20th of this year, there has been a date scheduled already for that motion, will in fact provide the court with the opportunity of hearing expert evidence with regard to the input they offered to the parties as to what would amount to the most appropriate approach to the distribution protocol. And I would point out that it is not at all unusual in the class action context to provide that detailed protocols are developed after approval of the settlement agreement, subject, of course, to the review and approval of the court. So that is something that in class action practice is often seen. Now, similarly, the challenges which you've heard of from the plaintiffs in designing the compensation for the Jordan's Principle and Trout classes and their associated family classes are, in our view, appropriately resolved by the approach taken in the final settlement agreement. Given the lack of data concerning those classes and the extremely broad range of products and services currently covered by Jordan's Principle as a result of the orders made by this panel, the approach of distinguishing between two basic groups based on the impact on the child of the denial or gap in service in order to determine which claimants were more significantly impacted, in our view, is both reasonable and indeed necessary. The Tribunal, as you know, of course, has noted that not all supports, products, and services currently approved under Jordan's Principle will meet the definition of essential services, and that some measure of reasonableness is required in making that determination. The approach taken in the final settlement agreement picks up on that proposition, and as you have heard, will attempt to provide both examples of what are clearly essential services and provide a process by which it will be possible to confirm by evidence of an expert, and that expert can be an elder in a remote community, for example, or a nurse attendant in a remote community, given the inability in some communities to have access directly to specialists in the field. That confirmation that a service was essential for a particular individual will, in our view, permit the compensation process to adequately recognize those individuals who suffered significant harms as a result of the denial or gap in service. The approach to the development of the criteria, which is set out in the affidavit of Janice Chevalier at paragraph 95, speaks of developing the criteria through consultation both with First Nations and experts in the field. And there is reference to a circle of experts which has been brought together by the Assembly of First Nations for that purpose. And it is, of course, designed to provide a solid, evidence-based framework for the delivery of benefits to those more significantly impacted by a denial, delay, or gap in service, while preserving the prospect of benefits to those less significantly affected. And in our submission, the focus on providing a prioritization for those more significantly affected is both appropriate and reasonable. Now, in exercising its ongoing supervision of the class action settlement, the federal court will necessarily review what is proposed with regard to the Jordan's Principle and Trout process, as well as with regard to the removed child process. And they will do that with a view to protecting the interests of class members and ensuring, equally importantly, that the approach remains in line with the terms of the settlement agreement and its underlying intention. So when the courts consider, for example, whether a particular distribution protocol ought to be accepted by them, they have, on the one hand, a view toward protecting the interests of the claimant community, and on the other hand, a view to whether what is being done accords with the terms and intentions of the settlement agreement, which forms the basis, of course, for the approach and must be honored on an ongoing basis. In our view, the fact that these issues will be determined at a later date should not prevent this panel from determining that the settlement does in fact satisfy the tribunal's compensation orders and framework. It's significant in our view that the settlement is supported by all of the rights holders before this tribunal, and there is evidence, which you have heard, of extensive consultations being undertaken both by the Assembly of First Nations and the Chiefs of Ontario. I can tell you that in answer to a question put by the Caring Society to Dr. Gideon, she responded that Canada does not have a role in those consultations as a result of agreement with the parties that those consultations are better undertaken by First Nations themselves. So Canada will not have a role in those consultations, unless, of course, specifically asked, in which case, of course, we will respond. But the intention is that it should remain First Nations led. So Canada will not anticipate a role in that regard. The settlement, in our view, is the result of a very hard-won consensus and will deliver significant benefits to many tens of thousands of First Nations children and adults, both now and formerly in care, as well as thousands or tens of thousands of those denied, delayed, or suffering a gap in services, whether in the Jordan's Principle class or in the Trout class. The Trout class's membership, as has been noted, reaches back to 1991, which is years prior to the articulation of Jordan's Principle, and extends compensation on a significant basis to all those who experience such a denied, delay, deny, delay, or gap in service during that period of somewhat more than 15 years, prior to the point at which the decision of this tribunal has impact. You have heard from counsel for the AFN that there is very broad support among First Nations for the settlement, and that expectations are high among the claimant community that compensation will soon flow to them. Canada firmly supports the settlement and asks the tribunal to confirm that the settlement does in fact satisfy the tribunal's compensation orders and the framework, and to make an order accordingly. I'm happy to respond to any questions. Those are Canada's submissions, subject of course to our reply following the submissions of the Caring Society. Thank you.
Thank you. Is it Canada's position that this will deal with the compensation portion of the case and not long-term?
Yes, absolutely, because the discussions and negotiations with regard to that long-term reform are continuing on a separate track. So it's not suggested that the order that we seek today before you has any impact at all on long-term reform, except for a timing impact. It's fair to say that if the tribunal were to find it not possible to endorse the settlement today, that it would potentially have an impact on the timing of the delivery of long-term reform. And that is because although the two are not specifically linked, it is the case that, as you know, we anticipate a motion to ask that the tribunal relinquish its jurisdiction on long-term reform once long-term reform is agreed to. And if compensation remains outstanding, then of course it would be impossible for the tribunal to agree to that. So there's necessarily a potential impact in that regard.
Thank you. Member Lustig, do you have any questions? Just a moment.
Yep. Yes. Thank you for your submissions. In your submissions, you mentioned that the FSA was not one for one, I think you used the term, with the tribunal's current decision order with respect to compensation. Can I assume that, and that the divergencies, I think it's been acknowledged, include some changes that would make persons eligible for $40,000 under the tribunal's regime, shall we call it, not eligible for that full amount necessarily under the FSA. And in some cases, or in one particular case, there would be no eligibility in the case of the estates. So can I take it that the reason that the tribunal is involved is to avoid the conflict that might arise with someone seeking enforcement of the tribunal's order if it wasn't made by the tribunal to comply with the agreement? Is that the most important reason why the tribunal is involved in this process now with this motion?
I would say yes, that is the primary motivation, to avoid a situation in which it would be possible for a claimant to apply, for example, both to the tribunal and under the final settlement agreement. The other primary reason, of course, is to recognize that the tribunal's orders form the foundation for the final settlement agreement, so that in order to ensure that we have reached a true consensus on the final settlement of all compensation issues, we necessarily need to seek the endorsement of the tribunal as well as approval by the federal court. So both of those motivations play into why we're before you today.
From a practical point of view, I put to you that it isn't likely that anyone who was going to get more out of the FSA, shall we put it that way, than less would be coming forward to look for enforcement of the tribunal's decision if it was to stand. It would always, the potential for you, the Canada, in terms of continued liability, shall we say, would always come from people who perceived that they were treated not as well by the FSA than they would have been by the tribunal's order. Is that a fair comment?
I think that is a fair comment. However, I think it's important, of course, to recall that this is a consensually negotiated settlement supported by the broad First Nations communities, and that the courts and the tribunal indeed itself have encouraged this notion of discussion-based, a dialogic approach to determining the issues before it. So that when Justice Fevell, for example, says that good faith negotiations are to be fostered and encouraged, he is necessarily thinking that there may be variances from what the tribunal or indeed the court may have ordered. And that is a necessary element of a consensual settlement, because there is always an aspect of compromise in any settlement, whether it's compromised by the defendant or compromised by the plaintiffs or the claimants' communities. There will always be circumstances in which there are benefits and potential detriments. Our view is that this settlement agreement delivers very much more in the way of benefits than detriments, and that on balance, it represents a fully reasonable and compelling argument for a final resolution of these claims, in order that compensation may now flow to the claimants, and particularly to those claimants most affected. Because we have maintained, all of the parties, including Canada, have maintained throughout the negotiations the focus on ensuring that those most affected receive not only the $40,000 mandated by the tribunal, but indeed a proportional enhancement based on their personal experience. So in our view, there are those benefits, and the benefits far outweigh the detriments.
Thank you.
Thank you. We would now be at a point where the Chiefs of Ontario present their submissions. So can I hear from the Chiefs?
Hi, yes, hello.
Hello.
So I guess we'll get started. So Bujo Nindaway
Are you ready?
I am ready. Absolutely.
Okay. Thank you.
Thank you. So Bujo Nindaway naman ganadak nimigwachan dam nun kisukan. Darren Bascadaway on Dejna Kaz Mang and Odam, White Senate Donjaba. Good afternoon, members, council, and those joining us on the webinar. My name is Darian Bascadaway, and I'm Loon Clan from White Sand First Nation. I'm a lawyer here at OKT, supporting Ms. Wente on this matter. As my first appearance as a lawyer ever, I'm very grateful for her continued mentorship to get me here. But before I get started, I want to acknowledge the children, the survivors, who have endured a worst case scenario of level of discrimination for no other reason than being themselves, for being a member of their nation. As not only leaders of tomorrow, but leaders of today, their resilience means so much for generations to come. They alone are our fortune and our sole hope for the future. Miigwech, 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 miigwech. So today, I'm here as counsel representing the interested party, the Chiefs of Ontario, or COO, as you've come to know them. The question COO engaged with primarily was whether the compensation FSA put forward by the AFN in Canada is fair, reasonable, and satisfies the tribunal's compensation order and related clarifying orders. The Chiefs of Ontario agree with the AFN in Canada so far that it mostly satisfies the orders, But we do not agree with the AFN's position in its reply submission, indicating that COO supports the compensation FSA without qualification. That's untrue. In our written submissions, the Chiefs of Ontario noted that the agreement is not without difficulty nor deficiencies. Yet on balance, the benefits of the proposed settlement outweigh the concessions that the classes had to make. The Chiefs of Ontario acknowledge that this compensation FSA is not perfect and doesn't meet the precise terms of the Tribunal's orders. But we are not looking for perfection in this extraordinary remedy to an extraordinary departure of human rights. We, the Chiefs of Ontario, are looking for a reasonable remedy that brings about a final result for children, youth, families, and communities who have suffered from Canada's discrimination for far too long. We're looking for results for youth, results for the communities, and results for long-term reform to benefit generations of children to come. And so relatedly, when addressing this question, the elected First Nations leadership in Ontario, represented by the Grand Chiefs and the Deputy Grand Chiefs of the PTOs, as well as the Chiefs of the Independent and Unaffiliateds, agreed to consent to the AFN's motion, thereby agreeing by extension that they are willing to endure the terms of the compensation FSA. So while we acknowledge legal arguments relating to the precise terms of the compensation FSA and the jurisdiction of the tribunal put forward by our friends at the Caring Society, CHRC, AFN, and Canada, we do not take a position on them, and we leave that to our friends. The Chiefs of Ontario submits that this panel accept the motion by the AFN, agreeing that the compensation FSA is fair, reasonable, and satisfies the tribunal's compensation order and all related clarifying orders. So subject to your questions, members, those are our submissions for the Chiefs.
Thank you very much. Member Lustig, do you have a question?
I just wanted to commend you. If that's your first ever appearance, you did really well. Thank you.
Yeah.
Thank you.
I agree.
I'm honored.
So we still have Anishinaabe Nation. I don't know if they are ready to proceed. Thank you again.
Yes, good afternoon. It's Christopher Rapson here for Anishinaabe Nation, and we are ready to proceed with extremely brief oral submissions in support of our written submissions. And I would just like to note, of course, thank you to the panel for hearing us today, and good afternoon to everyone listening on the webcast. Anishinaabe Nation does support and consent to the granting of this motion brought by the AFN and by Canada. We stand with our fellow representatives of rights holders in supporting the compensation final settlement agreement. While we acknowledge it is not perfect, we do believe it to be fair and reasonable. And I also want to reiterate Anishinaabe Nation's emphasis on the proportional allocation of compensation, whereby those most affected or impacted by the harms of the discrimination in question will receive the greatest compensation. And that's incredibly important to Anishinaabe Nation, particularly the recognition of the harms related to removal from a community, a remote community in the north. And we believe that's addressed through the proxies for harm that were described by the AFN in their submissions. We also want to just reiterate our acceptance of the finality negotiated and agreed upon in the compensation final settlement agreement. And once again, we support and consent to the granting of this motion, and we certainly hope that compensation will flow to our communities as soon as possible. Thank you. Subject to questions, those are our submissions.
Thank you very much. Any question? So it's almost 4, and we would now begin with the Caring Society, if that's acceptable. I'd like to hear from the Caring Society.
Good afternoon.
Good afternoon.
Good afternoon. I'm really in your hands. It may make more sense to start tomorrow so that I can kind of take what I've heard today and condense where necessary. But I'm also mindful that we started a bit late. So if you would like me to begin, I'm happy to. I'm really in your hands as to what you would prefer.
Okay, so let's start by asking, how long do you think that you need? I thought maybe 3 hours, but it depends on how long you need.
I would like to be less than 3 hours. That would certainly be my hope, but I've got a lot of sticky notes going right now. So I would say definitely around 3 hours.
Okay. And then we have the commission. Let's just ask the commission how long they think. Can someone from the commission tell me how long do you need for tomorrow?
Yes, I'm thinking 45 minutes at most.
Okay. And then it's a little bit difficult to plan the reply given that not all submissions have been provided. But I think that it's fair to say that tomorrow is sufficient to complete everything. Let's hear from everybody. Are you okay if we adjourn and start tomorrow at 9 or 9:30?
Chair Marshall, it's Paul Vickery for the Attorney General. Yes, I think that we could adequately deal with it tomorrow.
Thank you.
It's Stuart Wetke from the AFN. Yes, I think we can finish this tomorrow as well.
Well, let's make it simple. Does anyone object? No one objects? 1, 2, 3. No? Okay, so we'll adjourn and start at 9:30 tomorrow. Thank you very much for everything today and have a good evening.
Thank you so much.